You're the only one here. Nobody is there. So I'll read out only the operative portion. In the light of the above observations, this court is of the considered opinion that the petitioner has not been able to make out a case which calls for interference thereto. This petition is liable to be dismissed, which is done so herein. Petition disposed of, of course.
May I please, Your Lordship? Lordship, I beg to mention item number 8 and number 9, Your Lordship. If Your Lordship can kindly have this matter after 1 week, Your Lordship.
Let it be after 3 weeks, Your Lordship.
3 weeks, Your Lordship.
All keep on adjourning.
What is the matter about?
This is their case is suspension. Our case is abandonment of service, Your Lordship.
I keep hearing that phrase, but
Our Lordship.
the file is could not be opened.
Let it come after 3 weeks, Your Lordship. It's a matter are being adjourned off and on.
On premise by the petitioner, not objected to by respondent. This is matter after 3 weeks.
Your Lordship, similar prayer for item number 11 and number 12, Your Lordship. Matter still pending before the Honorable Supreme Court, Your Lordship. If Your Lordship can have it after 4 weeks.
But I think we have
May it please Your Lordship, give me that article. Lordship, this matter, both this matter are linked to item number 5.
right?
If Lordship is pleased to,
As far as 5 is concerned, it's only at the order stage. So
Supposed to take instructions.
Lordship, in fact, read petition number 465 of 2021. That is item 11. This matter can be disposed of, Your Lordship, in view of the letter dated 28/2023, Annex 14 at page 97 in item number 5. If Lordship kindly have item number 5.
If I may pray, let it be called out. I think it will be easier, my lord.
yes, let it be called up. Then we'll see how how it goes.
May it please Your Lordship. Lordship, I beg to make a mention of item number 7. Lordship, in this matter, we're still awaiting for instructions. I pray if this matter may be listed after 2 weeks.
In fact, last date they said they will ready for hearing. No more instruction. Because they took instruction, they said the case to proceed. But now they have to argue the case and justify how this order is bad.
2017 matter.
Yes.
Last chance may be given, Your Lordship.
We cannot go on like this.
If they are not interested, my lord may dismiss their case. My lord, this 2017 they have been seeking adjournment after adjournment.
For non-prosecution.
And here the thing is that, my lord, the officials, I'm representing 1 and 2, one the financial advisor and the director, my lord. They are retired persons, advanced age people, my lord. So and then as it is, there is no ground in the first place. There is no ground. And even the principal, the principal, the NEC themselves have said that all those projects that has exceeded more than 5 years should be closed. Yeah, that's the letter that we have.
Yes, that letter is there,
But I am also one of the officials. I already retired from service. My service benefit is withheld. They are not.
your status is immaterial. Whether you are retired or you are still in service, that is immaterial. When there is a proceeding pending against you, it will go on.
My lord, my lord.
So that is not
The thing is that
a
we
relevant
have to
factor.
discharge from the.
But the only thing is we have to look at the merits of the case,
My lord.
whether you have they have a case or not,
Yes, my lord.
and it's a revision petition.
Revision petition.
So
And this is
it is against the order of
Orders of discharge.
discharge.
order of discharge, my lord. And then how did the learned special judge CBI discharge us also, my lord? It is based on documents, my lord, which my lord had allowed us to produce before hearing of the consideration of charge. What had happened is allegations were there, FIRs were filed, investigation continued. Documents were seized by the CBI, and the documents, they were in the custody of the CBI. When they filed the charge sheet, they withheld certain documents. If those documents at first place comes to the court, would it show that there was no anomalies, there was no misuse of the funds, my lord. Then those documents are withheld, so therefore we came before this honorable court. And then this honorable court allowed us to produce those documents before the special judge. And when these documents are produced before the special judge, the judge took a lot of pain to go through just sieving all the documents. And finally came to a finding that there was no case made out. That is where the learned special judge has discharged all of us, my lord. Now, in my humble understanding, my lord, this is only a certificate revision petition, so to say, my lord. They just want to say that okay, we filed. So
We are not to
so what, my lord, what our objections are now, my lord? We normally we won't object to.
I understand. You see, this court has also. Who is leading in this case?
Mojika is
It was Dr. N. Muzika, Your Lordship.
He is not here.
No, Your Lordship.
Before there was a CBI counsel for the High Court, but now the CBI has no standing counsel. For that reason, the CGSC is appearing in this case. I think it's finding difficulty for this.
My lord, if my lord is going to give them accommodation, fine, my lord, but with some cost, my lord. So the next day they don't take adjournment anymore. Normally, we would say
Mr.
all
Yevin,
this, my lord.
Mr. Yevin, you know very well. The petitioner here is an organization. If you impose cost, the matter will go for approval till the head office, and by that time they'll ask for time and again to get instruction on that. So he'll not reach anywhere. Anyway, we'll give them time, but last chance.
Allow us 2 weeks' time, Your Lordship.
Fine, but last. Prayer is made on behalf of the Learned Senior Counsel, Learned DSGI, appearing for the petitioner, who is said to be indisposed and could not appear for the court today. The Learned Counsel for the respondents have not objected to the prayer made, but has pointed out that this matter has been pending for so long, mostly on the ground of delay caused by the petitioner. On prayer made, the court is constrained to allow the same. However, it is made clear that no further adjournment will be allowed, and matter to be heard definitely on the next date fix.
Highly obliged, Your Lordship.
This is matter for 2 weeks.
May it please Your Lordship, I beg to mention item number 6. Your Lordship, I pray for some accommodation in this matter, Your Lordship.
What's the matter? I think this here also, we have made it very clear that this.
And on the last occasion, the Learned Senior Counsel had made a submission that if he doesn't appear, another counsel will be.
Yes,
Time
so-
and again, my lord, this is.
Yes, I mean this cannot go on like this. Where's Dr. Muzika? He's not in station.
Your lordship is there, your lordship. He needs some time, your lordship, as you was not aware, your lordship.
Just now submission was made that he is not in. Yeah, he's not in the court. Now you see he's here. Where is he?
He's on his way, your lordship.
On his way.
On his way.
We'll take it up at the end of the boat. Just try to contact him. We'll wait.
Much obliged, lordship.
Supplement to costless, item number 2.
May please, your lordship. Lordship, this is a bail application.
Yes.
Now, my lord, what had happened in this case? Police allegedly had received some source information that some people were moving with some smuggled gold bars. Now, my lord, that was on 5/10/2023. The police of Barnyard Police Outpost. My lord, subsequently, a NACA was being conducted. A tourist taxi was intercepted, and 3 persons were found inside. A lady passenger and the present accused and a driver. Police, on thorough search, they seized 7 numbers of gold bars from the possession of the lady. Nothing could be seized from the co-passenger, that is the present accused here, the petitioner, and from the driver. But surprisingly, my lord, both the co-passengers, they were soon arrested, and my lord, a case was being registered, and the case has been registered under, my lord, very inappropriate sections. That I'll come to it, my lord. First, my lord, the sections that was charged with was, first is 120B, punishment for criminal conspiracy. Then 329, voluntary causing hurt. Now, what is the question of hurt in this case? 420, my lord, cheating and dishonestly inducing delivery of property. Now, 424, dishonest or fraudulent removal or concealment of property. Then again, 467, forgery. Then 468, forgery for the purpose of cheating. 411, that is dishonestly receiving stolen property.
It's not. You see, it's too early in the day to.
My lord, yes.
go into this.
I'll sum up, my lord.
That will be
Why
subject. That will be subject to investigation.
my lord. Why I'm submitting, my lord? I'm coming to that, my lord. This is relevant at this point of time, my lord. Now, what has happened, my lord? It is the custom officials who has got the absolute prerogative in cases of smuggled goods. But, my lord, there again, under certain circumstances, police receives, they are in a crucial situation where they receive source information, the smuggled goods are being delivered, my lord. In that situation, it will be difficult for the police to communicate with the custom officials. So, the law is that, my lord, the police has got the power to make the seizure and also register a case, and, my lord, immediately, as per the Custom Act, my lord, immediately they have to communicate with the nearest custom department and also make them a party during the trial, so that the smuggled gold, its value can be calculated, the quality of the gold, and if any duties has been, my lord, that has escaped from the, that has been, my lord, misappropriated by the accused, my lord. In that situation, my lord, it is the custom officials. So, what my submission is that, my lord, police has rightfully registered the case, in the present situation, though the sections may not be, my lord, that will be a subject matter at the time of framing of charges, my lord. My submission here is that, my lord, admittedly, this is a case of smuggled gold. So, my lord, under what provisions the offences of smuggling, my lord? Kindly come to, my lord, Custom Act of 1962. Section 404 at page 74. Lordship got
Section?
it? Section 104. That is the power to arrest. Custom Act 1962. May I read, Lordship?
Yes.
If an officer of customs empowered in this behalf by general or special order of the commissioner of any person in India or within the Indian customs waters has committed an offence punishable under section 132 or section 133 or section 135 or section 135A or section 136, he may arrest such person and shall as soon as may be inform him of the grounds for such arrest. Every person arrested under subsection 1 shall without unnecessary delay be taken to a magistrate. Where an officer of customs has arrested any person under subsection 1, he shall for the purpose of releasing such person on bail or otherwise have the same power and be subject to same provisions as the officer in charge of a police station, and has in his is subject to under the Code of Criminal Procedure 1868. Notwithstanding anything contained in the Code of Criminal Procedure, number A, prohibited goods or evasion or attempted evasion of duty exceeding 50 lakhs rupees shall be cognizable. Save as otherwise provided in subsection 4, all other offences under the Act shall be non-cognizable. Now this is important, my lord. Subsection 6. Notwithstanding anything contained in the Code of Criminal Procedure 1973, all offences under the Act shall be bailable.
Where is it?
My lord, that is subsection 6.
An offence punishable under section 135.
No, my lord.
You're reading?
That is section 104,
104.
subsection 6.
Subsection 6 is so.
Yes, my lord. Also got it?
Yes, I've got it. This is 6.
Yes, subsection 6. Notwithstanding anything contained in the Code of Criminal Procedure, all offences
Yes.
under the Act shall be bailable.
Where are you reading all of this?
If I may.
Just now you have read,
Section 104.
104, power to arrest.
Yes.
Subsection
Then 1, 2, 3,
1, 2, 3,
4, 5, 6.
And 6 is,
Yes.
6 is only relating to section 135.
6, my lord, notwithstanding anything contained in the Code of Criminal
Yes,
Procedure.
that is there.
Yes.
An offence punishable under section.
All offences under the Act shall be. So,
Where is that?
Not all offense, under section 135 only.
What are you reading, Mr. Moon?
my lord,
I'll show you this book.
in that case, my lord, kindly come to section 135. Kindly come to section 135. For clarity, my lord. 135.
Yes.
May I read?
Yes.
Without prejudice to any action that may be taken under this
This
Act,
heading is this evasion of duty of prohibitions.
my lord. Now, what this section says, my lord, is that any offences, smuggled goods, if the total value of the smuggled good is beyond 1 crore, then the punishment may extend to 7 years. But anything below, my lord, 1 crore, it becomes bailable. The punishment is, my lord, will come to section 135. clause 2 at the end. In any other case with imprisonment for a term which may extend to 3 years, or with fine, or with both. So, my lord, the present, my lord, what is the quantity of gold seized in the present case, my lord? My lord will come to page 4 of my petition, paragraph 8. May I read, my lord?
Yes.
That in the present case, the quantity of the alleged gold seized is 860.31 grams, and the present price of 24 karat gold in India stand at rupees 6,024 per gram, which when multiplied by 860.31 comes to rupees 51 lakhs 82,500.44 paisa, which is an bailable offence by virtue of section 135 of the Custom Act. So, my lord, this is the present situation, my lord.
But you have not been booked under the provisions of the Custom Act.
My lord?
You have not been booked under the provision of the
Exactly.
Custom
Exactly,
Act.
my lord.
So,
Exactly, my lord.
as you see, as and when that situation is reached, then
Exactly, my lord. Now,
prima facie-
I'm coming to the...
prima facie we are looking at the
My lord, yes. My lord, yes.
the
Absolutely
FIR
correct, my lord.
here.
My lord is absolutely correct. However, be that as it may, my lord, apart from this, of course, there are lots of discrepancies out here that I'll agitate before the trial court below. At this juncture, my lord, more than 1 month, about 45 days is already over.
And we'll yes.
Wait, please, Your Lordship. What my learned friend has just submitted, Your Lordship, is not relevant at this stage when he is moving bail, Your Lordship.
I'm accepting that, my lord.
What the Customs Act and that there is a bar, that he has not been able to show that there is any bar that a police officer cannot investigate or arrest people who have been found with smuggled gold, Your Lordship. And Your Lordship, in course of investigation, the accused here has admitted that he procured the gold from another gentleman, and the police are now trying to get hold of that gentleman from whom the gold was procured. So, Your Lordship, it's too premature to release the accused person on bail at the moment, Your Lordship, because
call for the-
investigation is. We'll call for the CD, Your Lordship, and
my
then Your
lord.
Lordship can decide.
My lord, yes.
Only the state is a party.
My lord?
Only the state is
Yes, my lord. Under the state,
the state and the
State, yes.
yes,
yes.
in charge
State.
Heard Mr. Arborun, Leonard, counsel for the petitioner, who has submitted that the petitioner has moved this application for grant of bail on behalf of the accused, Sri Sadeep or Sandeep?
Sadeep, S-A-D-E-E-P.
Sadeep Kumar Sunar, who was arrested in connection with Nongpo PS case number 116 under bracket 10 of 2023 under section article section no? In course of hearing, the Leonard Miss the Sharing Leonard AAG has submitted that the case diary may be required to be produced by this court before any final order is passed in this matter. Accordingly, the copy of the case diary of the said Nongpo PS case number 11610 of 2023 is hereby called for. Prosecution to produce the same on the next date fix. How soon?
3 days.
Next Tuesday or Wednesday, Your Lordship.
21.
21. Yes.
This is matter on 21.
Deeply obliged, madam.
Pleasure.
On daily cost list, item number 1.
Your Lordship, I appear for respondent number 12 here.
My Lord, I seek some accommodation from my Lord. What happened in this case? In section 11 notifications, name of the petitioners were mentioned on the Land Acquisition Act. Now, thereafter we challenged that provision action before this honorable court. Now, during the pendency of this very petition, the government had issued a section 19 declaration of the 2013 Act. And there now, the name of the NOGMA is included, and name of all the writ petitions from 7 villages were removed. This they came to know recently. Therefore, they proposed to have a meeting with the NOGMA, who clearly said that I'm not the landowner. I have administration over the area. The landowners are with the individuals. So, Lordship, they proposed to have a meeting coming soon.
How would that affect your case?
Now, if I don't challenge, if I don't clarify this, then, my Lord, if my name is not available under Section 9 in declaration, my inclusion in Section 11 prelim notification doesn't serve any purpose. It has to go together, my Lord. That effect is there, my Lord. Therefore, the call for a meeting. So, Lord, may I pray for 2 weeks' time, my Lord, given the effect.
I think they have served it in the old office, Your Lordship.
Okay, you can give him an extra copy.
Any local council is there
Who is
with
the
my
local
friend, I
council
can
here?
serve.
I'll send it to the Learned Senior Chamber.
Well, we will serve. We will serve.
Mr. Your name is not appearing in the proxy. For the sake of our PS, what again? Just repeat your name.
P.R. Paske.
Ayo. Mr. P.R. Pascal and the council has submitted that he is entering appearance on behalf of the respondent number 9. However, copy of the petition has not yet been received by the said respondent, for which the petitioner is requested to supply a copy of the same. The Mr. Secretary Learned Counsel for the Learned Senior Counsel appearing for the petitioner has submitted that along with the notice issued upon respondent 9, the copy of the petition has been enclosed. However, for convenience sake, it is the Learned Counsel has submitted that the copy will be issued upon respondent 9 in due course.
Other respondents are yet to file affidavit also.
So all the other respondents are in attendance.
Lordship, I'm appearing for respondents number 3 to 7, my Lord.
3 to 8. And what about 1, 2?
Union, my Lord.
Yes. Who's appearing for union? Are they necessary parties?
They have received a copy of it.
CDC, Lordship.
So all the respondents have not filed their counter.
No, my Lord.
The respective counsels for the learned counsels for the respective respondents who have received notice has submitted that the counter affidavit could not be filed today and has sought for some time for the same to be filed. On premium, same is allowed. This is matter up to
2 weeks.
2 weeks.
Much obliged, Lordship.
Item number 3. Please, Lordship. Lordship, on the last occasion, the prosecution, the state has said to produce this 164 confession of the accused as per the order of the last order of this honorable court.
It was not required.
This matter has been charged sheeted?
It's charged sheeted, Your Lordship. So, on the last occasion, when I moved the bill application, the submission was made
Yes.
by.
In fact, in your petition, you have enclosed the all the relevant. Is it?
Yes.
No,
So
have you
no
enclosed the charge sheet?
Yes, Lordship. So no confession under section 164 of the accused person has been recorded. That was my submission which I made on the last occasion also, and then the counsel for the state has prayed for time to produce the 164 confession of the accused person. So as per the documents supplied to me, no confession under 164 was recorded. So if
Yes, sir.
Lordship, it was a 161 statement, Lordship, which was not enclosed. Lordship, on the last date we had, I had undertaken to produce the documents pertaining to this particular case, that is the charge sheet. Lordship, in this particular case, I'd like to point out that when the phone of this the co-accused person was seized, Lordship, the court records were basically taken, traced, and it shows that the co-accused and the accused person, they have had constant touch with each other. So therefore, Lordship, and in this particular case, on the previous date, my learned friend here had relied on this Tufan Singh judgment. And Tufan Singh's judgment in page number 4 of paragraph 5, Lordship. Page number 4 of paragraph 5.
Is it 4 of what?
Of this bill application, Lordship. So therefore, Lordship, that is in the second last line, Tufan Singh versus State of Tamil Nadu. So therefore, Lordship, this basically what this judgment says is that any statement given by the accused person before the police, the accused cannot be convicted solely on the basis of that statement given before the police. However, Lordship, there's a big but in this case. That is that if this same statement which is given by the accused to the police is corroborated by any other further evidences, so in that case, Lordship, this same judgment says that the statement can be used against the accused. So therefore, Lordship, in this case, as I've pointed out, Lordship, in this case diary right now, I'm pointing out that there's the call records over here between the co-accused and the accused. So therefore, this corroborates with the statement which has already been stated over here in the same page number 4 of paragraph 5. The accused person has already stated that she had indeed handed over the contraband to the co-accused person, and her statement is here as well, Lordship. That along with the corroboration.
So let us be clear.
Yes.
Her statement under section 164 was never recorded.
Never recorded.
161. So you're relying on that.
And with the call
the
records,
CDR, of course.
Yes. Call record details.
I finish.
So therefore, Lordship, the Tufan Singh judgment will not be applicable in this case. Necessary orders may be passed.
Have you point out the specific paragraph in the said judgment?
Yes, Lordship. The relevant part is.
You are referring to the case of Tufan Singh, where you say there there is an observation made therein that in case there's corroboration, then that statement will be taken. So
Yes,
where is that specific
Lordship
paragraph?
will supply it during the course of the day.
You have to specify this.
Yes, Lordship.
Because it's a huge judgment.
Yes, Lordship. Yes.
You do that.
If my learned friends have finished, I may be allowed to reply to the submissions made by the state. Your Lordship, here, what my learned friend has submitted with regard to 161 statement. 161 statement is with regard to recording statement of the witnesses. It is specifically mentioned in the statute. It is for recording the statement of the witnesses, not the accused. And confession under 164 of the accused person, confession and statement, that is given in 164. Now, if the police says that the statement, that the accused person has confessed before them at the time of during investigation, which they are relying upon with the statement, with their confession, which is made under Section 25 of the Evidence Act, confession made before the police, which is not admissible. And the police ought to have immediately, if at all the police find that the accused person has confessed before them with regard to some certain commissions of offence, it is under Section 26 of the Evidence Act, it is the duty of the police officer to send the accused person before the magistrate nearest to the police station to confess his to send the accused person to confess before the magistrate under Section 164, in this case that was not done, to your lordship. So any confession which they say that it is made before the police officer, it is not admissible. And with regard to Tufan Singh, which I have stated in my petition, that was only for the purpose of admissibility or inadmissibility. But in Tufan Singh, that was the case of where the custom official, they are not considered as a police officer or not. So in that case, it was considered and said that like the custom official will be considered as a police officer. So the statute is very clear that any confessions which is made before the police officer is not admissible in evidence. And now apart from this confession, which they say that the accused person and the co-accused person has confessed before the police, there is no material on record to show that there is a prima facie case against my accused person. And now there are some of the evidence which has been recorded before the learned trial court. There is not even a single whisper about my accused person. When we go through
evidence has been let in this case.
Some of the witnesses, but it's going on a very slow pace. The evidence is going on a very slow pace.
Witnesses were examined? And have you pointed out?
Lordship.
Have you pointed out in your petition how many witnesses have been examined?
Not exactly given the time, because like it is still at the stage. So on the last date also the witness did not come.
How many witnesses were examined?
Four examined already, Lordship. So now
So in that case, you see, this bail application has come post filing of charge sheet.
Charge sheet, yes.
So what is to be considered is the matters we looked into the merit of the case.
So the entire charge sheet, yes, Your Lordship.
So what would be relevant here, apart from the CD, of course, that is that is before the charge sheet is filed. Anyway, it's just for the interest of this court to peruse the CD. But if you say that evidence has been recorded, then we would like to look at what the evidence has revealed, particularly against you. Do you have copy of those?
Yes. Okay.
Yes, Mr.
Yeah.
Baba.
Yes. Certified copy obtained, like whatever. Yes. So far, which is examined, and then on the last occasion also there was no witness. So no, not even a whisper. As we go through the entire charge sheet, also, Your Lordship, and the entire charge sheet, and all the evidence which has been recorded, the evidence is related with the co-accused person, from whom the contraband items was alleged to have recovered. And the prosecution has said about the CDR, there is no CDR also in this case to show that, as per the charge sheet, no CDR report is there.
It is there. The call records have been recorded.
It is not sent to the court.
Yes.
The call record are not sent to the court along with the charge sheet.
So basically your contention would be that the accused person is not involved in the case?
Is not involved in the case, and there is no prima facie case against the accused person, except the alleged confession which is made before the police and which is not admissible in law, Your Lordship. As per the petition, list of document. So, at page number 18, what the list of document in my bail application where the prosecution has relied upon for putting the accused person on trial. So as per the charge sheet is at page number 18. So these are the documents which they have forwarded before the court for the purpose of, so as per page 18 of my petition, the list of enclosures are rough sketch map, PO, intimation to superintendent of police, departure, gazette police, then number C is authorization certificate, then D, notice under section 50, then E, preliminary test report, F, weight and measurement certificate, G, punch number, photograph of C's photograph, then H, original C's Caesar list, then statement of complaint, SI, statement of witness of so-and-so, and statement of witness of so-and-so, statement of witness so-and-so, statement of witness so-and-so, and then statement of Caesar witness so-and-so, interrogations of the accused Sri Pramod Chetri and so-and-so, that is that statement. Confession, interrogation statement of accused Miss Nay Mercy Sensit, my accused, re-interrogation statement of accused person Miss so-and-so, inventory report of vehicle number, FSL report. So as per the list of the documents which they have forwarded to the court for the purpose of the trial, no CDR report is, and no section 65B.
So nothing has been included here.
Yes, Your Lordship. Except the confession, which of the...
That would be a very weak link, of course.
That is true, my lord.
But CDR, why you have relied heavily on the CDR? Why you have not, forwarded it to court?
The lower court record is not before your lordship. It's difficult to.
See,
Yes,
look at
they
this.
could have agitated under 207 when their copies were supplied also.
No, it suits them. Why would they?
That is their mind.
Why would they agitate? It is for you to bring that on record.
I cannot go beyond whatever is there.
Lordship, she has been there for more than 6 months or so, trial of going slow pace, and she's a lady of a young lady and no criminal antecedents, background and all, and it's under 21B and all, under section 437 proviso also it provides, and
21B or 21C?
Lordship?
21B or 21C?
21B, Lordship.
Intermediate?
Intermediate quantity. So recently Lordship was also appreciated with regard to...
No, the only thing is distinguishing factor between 21B and 21C is the applicability of section 37.
Yes, Lordship, yes.
Admittedly, in this case, it is not applicable.
Yes. I humbly pray, Lordship, and she'll abide by all the terms and face the trial, Your Lordship.
I'll go to the CD and I'll pass this orders.
Diplomas.
Highly obliged.
Item number 4. Much obliged, Lordship.
May it please Your Lordship, as per the last order, Your Lordship has allowed us to take fresh steps, Your Lordship. We have done so, Your Lordship. If Your Lordship may allow us to file an affidavit of service, Your Lordship.
So the notice has been affected?
As per the tracking report, Your Lordship, the item has been delivered, Your Lordship.
On? Okay, only on. Okay.
On 14th.
Miss learned counsel appearing for the petitioner who has submitted that the notice issued upon the respondent has been affected. However, it is prayed that the affidavit of service may be allowed to be filed in due course, in course of the day.
Your Lordship, 1 week, Your Lordship, because we're still awaiting that from the post office, Your Lordship, the consignment report, Your Lordship.
So it has not been confirmed then?
Your Lordship, through online, Your Lordship, we have...
in course of the day, within the next date fix. As prayed for, this is matter after 1 week.
Much obliged, Your Lordship.
Item number 5.
May it please Your Lordship. Lordship, in this matter, item 5, Your Lordship, I am seeking for some accommodation, Your Lordship. I am yet to receive instruction, Your Lordship.
Who is appearing for respondent 2? Mr. Indishwar Leonard DAG has sought for accommodation in as much as some time is paid for the counter affidavit to be filed. Pray allow. Mr. has entered appearance on behalf of the respondent 2 and has also sought for time to file the counter affidavit. On preemit, this is matter to 2 weeks.
Then 11-12, Your Lordship, will come along with this.
Let us see.
11 and 12, 11 will be the same advertisement.
Yes.
Which is with item 5.
Basically, what is it, Mr. Dev?
Lordship, our case was that there was an advertisement in 2017. We had applied for the post through direct recruitment. The entire process culminated till the interview. However, the results were never declared. In the meantime, my lord, another advertisement was also floated for another 2 posts. That advertisement was, my lord, subsequently annulled by the government. And at the same time, also, my lord, certain persons who were already in service, who were supposed to be promoted, Lordship, had also approached this Honorable Court as well as the Honorable Supreme Court in view of a certain, there was an issue with the qualifications, Lordship.
In connection with the selection process wherein the, I mean, you had applied for.
No, that was for the promotional post, my lord. We are for the direct recruitment.
No, yes, you have, you see, an advertisement was floated. You had applied for the same.
Lordship.
By, direct recruitment.
By direct recruitment, Lordship.
That, the process was stalled at some point of time.
Lordship.
Excuse me. So, you have come against that.
Lordship, yes. And our case is that the matter that is pending before this Honorable Court as well as that in the Supreme Court has nothing to do with this advertisement, Lordship.
Okay. Oh, so this the process was stalled because of the.
There was a confusion that there was a stay.
Of the other case.
No, Lord. There's no such confusion. The same advertisement which my learned friend is before this Honorable Court, I have filed a petition claiming that the 2 posts which have been advertised, they are actually promotional posts. So there cannot be any advertisements for direct recruitment. Therefore, your lordships have stayed the advertisement.
No. I'm not.
That is for the subsequent 2 posts. But
Yes.
you were.
I'm for the original 4 posts.
4 posts.
I have filed 2 petitions.
Against those 4 posts also.
2017 advertisement, 2020 advertisement.
Okay.
Issue is, my lord, whether it's the direct recruitment and the promotional has to be.
I approached this Honorable Court on the ground that the service rules provides that 33% is by promotion, 67% is by direct recruitment. Now, direct recruitment posts are all filled up here. So, the posts which are vacant, which are being advertised, are actually posts which are reserved for promotion. Therefore, your lordships have granted a stay. It is on that ground that they have come before this Honorable Court that the
two are
process
different.
has been stalled. So, not it's interlinked. It's the same issue.
If lordship is kind.
So the issue to be decided as far as your case is concerned is whether the post advertised should be by direct recruitment
or by promotion.
By promotion.
If lordship kindly has page 97 of item 5, my lord. This is the final communication in respect of all the.
No, that relates to the advertisement of 2020, your lordship. That is writ petition number 465, your lordship. That 465 writ petition will become infructuous, your lordship, in view of this letter.
Page 97, my lord, annexure 14 of item 5.
Yes.
Lordship, this is a letter of 28th August 2023. Lordship will see, with reference to the letter on the subject cited above, I am to clarify that 4 posts of enforcement inspector advertised by the commission by so-and-so, dated 26/4/2017, falls under 67% direct recruitment reservation and will not attract violation of the pending court case, as the vacancies are to be filled up by direct recruitment at the 33% reserved for promotion from amongst the graduate assistant enforcement inspectors are still available, and over these 4 posts. So they are saying, my lord, that with respect to the 2017 advertisement, the 4 posts are to be filled by direct recruitment and the 33% reservation posts are available, excluding these 4 posts. And in the second paragraph, Lordships, reiterating the contents of the letter of even numbers 218 dated 20/07/2023 addressed to the Deputy Secretary Government of Meghalaya Transport Department, it is further clarified that the claims for reservations of 33% posts for Assistant Enforcement Inspector does not apply at present, as all Assistant Enforcement Inspectors were reverted to the post of Enforcement Checker, consequent upon the High Court judgment orders since the 21st of March 2022. Hence, the advertisement floated by you on the 2 vacant posts, wide number so-and-so, dated 14th December 2020, may be treated as cancelled. So, my lord,
that is writ petition number 465 of 2021, Your Lordship.
So the 2020 advertisement has been cancelled.
That has been cancelled. So
let the counter be filed. All these 3 matters can be taken up together.
You are party here?
I'm not party in this item 5, Lord. My writ petition is separate. Item 11 and item 12.
But you see, you have also mentioned that all the matters are interlinked,
Yes.
in as much as the 4 posts which were advertised, as contended by Mr. Deb, that they are supposed to be for by direct recruitment. You have said otherwise.
Yes, Lord. And there's a stay on the advertisement.
There's a stay.
There's a stay.
But here it is clarified that it has no, it has no connection with the pending cases.
And they are saying categorically
I'm
that
not aware of this. I have my own case to argue. There are total 21 posts. Out of 21 posts, 15 posts are occupied by direct recruitments. That is 67%. Remaining 6 posts, out of the 21, which is the 33%.
Yes.
That is supposed to be reserved for promotion.
Okay.
So that is my case.
That is understood.
That is my
Now, out of those 6 posts, are these 4 posts included in those, from those 6 posts, or
their clarification, it appears it's separate.
because we don't see now, we are not.
That is for the
clear.
state to answer, my lord. I will argue my own case. My learned friend will argue his own case. The
Yes,
state
you
will
have to.
clarify.
Yes, you have to clarify. If what Mr. Nobri says is the correct picture, then we are left with 6 posts. Out of those 6 posts, perhaps 4 may have been advertised, as in the case of Mr. Dev, or it could not be. We don't know. That position has to be clarified. See, the only thing is that once we are clear on this, then we know how to segregate which are meant for direct recruitment, which are meant for by promotion.
in their case also, Your Lordship, first the issue of locus has to be.
Oh, that of course. That's you said.
Subject to arguments.
But so far, item 11
as far as
is
their case is concerned, you see, the issue of qualification is a different issue altogether.
Lordship. So far that writ petition 465, Your Lordship, in view of that letter at page 97, so that matter become infructuous, Your Lordship, because that advertisement for 2 posts had been withdrawn by the government. So that can be closed, Your Lordship.
My writ petition, without me having any information,
Yes.
they should file something in my writ petition.
So they have to. You have to file.
Lordship, then
Basically, you
we'll
have to file an
accordingly,
affidavit.
Your Lordship.
You see, you have to bring this by way of an
We'll file
affidavit.
it accordingly.
As far as this case is concerned, you cannot just.
Your Lordship. Then it'll come along with item 5, Your Lordship, after 2 weeks.
Fine. So as far as these cases are concerned, Mr. Dev, what we will do is, order will be passed that the counter affidavit may be allowed to be filed
Lordship.
by the respondent, and then we'll see how it goes.
state may also file an additional affidavit in first item if they want to bring that.
Yes, that will do.
Can be
Certainly will
taken
do.
up altogether.
That is a different thing. Let that order be passed. Okay, now ada pass ni order tu. I have already passed the order.
Lordship, yes.
Much obliged.
So that will be.
Item number.
Take up katuka.
11 and 12.
11 and 12.
Just in these two items.
As far as now, let's come to 11. This is 465.
465, Your Lordship.
So here,
So that also will file, Your Lordship, will bring that documents by means of an affidavit.
so that they can respond.
Lordship, yes. Then in item 12 also will will file the affidavit, Your Lordship, will to clarify whether these the posts which had been advertised are promotional or by direct or direct recruitment.
So here, what is the role of the MPSC here? Who's appearing? You are appearing.
MPSC because they are it is because they are the advertising agency, Your Lordship.
They have conducted the
Conducting the selection process.
Heard Mr. Additional 100 AG who has submitted that communication dated 28/8/2023 has been issued by the Commissioner of Transport. Communication date I ko number ho hai communication number ka to dated to the Secretary Meghalaya Public Service Commission Shillong. Such communication is relevant to the subject matter of this case, for which prayer is made for an additional affidavit to be filed to bring the said communication on record.
Lordship, not additional affidavit, Your Lordship, because we have
Oh,
not
you have
filed
not-
affidavit.
oh, you have
We
not
haven't
filed.
Your Lordship.
By way of an affidavit, no?
Lordship, yes.
On premier, the same is allowed. As far as the counter affidavit is concerned, the AG has submitted that he may be allowed to file the same within the next date fix. What about for MPSC? Who's appearing? No, have you filed your counter? You have not. Similarly, the counsel for the respondent 4 has also sought for time to file the counter. On premier, this is matter to 2 weeks. So, now
Then item 12 also, similar prayer, Lordship, for filing of the affidavit.
filing of affidavit, but
Lordship.
not to bring this
No, Your Lordship.
to your respondent 4 has not entered appearance. What is the MPSC? Okay. Mr. B. Graham, legal counsel, has submitted that he is entering appearance on behalf of the respondent 4 oblique MPSC and has sought for time to file the counter affidavit. Similarly, Mr. Additional Learned Counsel, Learned AG, appearing for the respondents 1, 2, and 3 respectively, has also sought for time to file the counter affidavit. On prayer made, seems allowed. This is matter to 2 weeks.
Oblige, Your Lordship.
Item number 6.
Excuse me. Yes, Miss. Kelly?
Your Lordship, the senior counsel is on next, Your Lordship.
My friend can start for the other matter because there are two matters connected.
Hello, I have last occasion, my lord, I have almost argued most of my case. But this case here, the issue in this case.
Have you? I think the
28.
On the last occasion,
yes,
it was Mr. Dingdo who had
yes, on
started
the,
with the
ground of maintainability.
You have
Well,
responded to that?
I have responded to that.
Yes,
My contention is that 227 will still be maintainable because 227 is not only supervisory but corrective as well. And on the face of the judgments impugned in this 227, we have assailed the entire proceeding. The entire proceeding is hit by it is a perverse finding. Perversity is one of the ground where a court under 227 can look into the propriety of the finding of the court. Now, here is a case where a money suit was brought in before a court. The disputed amount. Was 1,50,000. I'm sorry, my lord. Was 1,50,073,101. Now, this was the disputed amount in respect of the bills. Now, this case has a checkered history in the sense that the amount due to the respondent in the present proceedings before your lordship was for a sum of rupees 2,66,28,831. Now against this, they came to the Honorable High Court, then Guwahati High Court, by way of a writ petition, which was registered and numbered as WPC number 168 SH of 2003. Now in WPC number 168 SH of 2003, we admitted our liability to the extent of 1,15,44,930 crores. Now this is our admitted liability, and the rest we say they are case of double billing and which was disputed. Now after that, the court ordered that we pay the admitted amount to the respondent here, petitioner in those proceedings, and with regard to the disputed amount, they were given the liberty to file an appropriate petition before the court of competent jurisdiction. Now, in due course, we paid a sum of 50 lakhs 244 to the respondent. Thereafter, they came again to the then Guwahati High Court by way of another writ petition. That was writ petition number 407 SH of 2005. Now, there they sought direction for seeking release of bills to the extent of 2,19,28,031. Now, this petition was disposed of by the Honorable Guwahati, the then Honorable Guwahati High Court, directing us to pay the respondent the balance of 65,44,606, which was the admitted amount after the amount of 50 lakhs was paid to them. And with regard to the other disputed amount, that is 1,50,73,101, they were asked to seek remedy before a court of competent jurisdiction by filing an appropriate petition. Now, my lord, what happened? They filed a money suit. Now, they filed a money suit for a sum of, in 2009. In 2009, they filed a money suit for a sum of 8,88,444,824. From where this figure came, we do not know. Now, it appears that the money suit was filed by them by compounding the interest. quarterly at about 12% per annum. Because if it is only when you compound the interest quarterly at 12% per annum, you will reach this figure. A sum of 150,73,101, which was due in 2000, this figure would have been arrived at. Now, the matter proceeded before the court of the first instance. It proceeded against us. The state entered appearance. However, it was not contested fully. The matter went ex parte against us. The suit was decreed. Now, the suit was decreed to the tune of 1 minute. For the same sum, 8 crore 88 lakhs 44,824. The suit was decreed. Now, my first contention, my lord, here is the law provides that under section 34 of the CPC, it says that any interest in any suit for recovery of monetary dues or otherwise, the interest has to be compounded on simple interest basis. There cannot be any component of compound interest. My lord, as on today, for the sake of argument, if I were to admit the entire liability, if I were to admit just for the sake of argument, my lord, they will be entitled to not a penny more than some 3.5 crores. Now, what they are seeking, what they contend their entitlement as on today is about 10 crores. Had we applied the correct interest rate, had the code below applied the correct interest rate, they would not have been they would not be entitled to a single penny more than 3.5 crores. But since compound interest was applied, so this abrupt figure has come up. Now, who is to pay this? The state exchequer. This is public money, my lord. This is siphoning of a public money, squandering of public money, my lord. I would say that. Now, my lord, so the law.
So it boils down to only one thing. The
finding is perverse, my lord.
No, the finding
is perverse.
It boils down to one thing, that is calculation of interest.
Calculation of interest, my lord.
Whether it should be simple or compound.
One thing, my lord, that is one aspect of the matter. Now, other aspect of the matter which my learned senior friend has argued is that since this matter has reached the stage of second appeal. Now, my lord, in the second appeal, in a very strange manner, a concession was made. The second appeal came up for motion, and on the date of the motion, a concession was made that we will pay whatever is the double billing. Save and accept the double billing, we will pay whatever it is. I mean, whatever is there.
Whatever has been calculated.
Yes, whatever has been calculated. Now, my lord, the law is fairly settled, my lord. A finding in a second appeal without formulation of a substantial question of law is no finding at all, my lord. Such kind of concessions cannot be made in a second appeal. Now, number two, my lord.
So you have assailed that before the Supreme Court?
No, my lord, we have not. My lord, that we have not done. Admittedly, we have not done that. So, my lord, that is why, my lord, my contention here is, my lord, this court sitting under 227 can also look into this aspect of the matter also, my lord. My lord, admittedly, it was not done. I'll fairly concede to that. It was not done.
You have to, Mr. Gautam, you have to back up with a very, very substantial authority on this.
My lord, but my lord, any finding in the second appeal, my lord. My lord, when there is a law which says it's no finding at all, my lord.
Exactly.
Now,
exactly. But who is to decide that? Who is to decide that except a higher forum? Admittedly, the process was, wrongly conducted. Whatever, wrong order was passed. But who is to decide that this is wrong and this is right? Except which admittedly you have not gone.
My lord, that is again a debatable issue. I will try to satisfy my lord.
That is why I said
I will try to satisfy my lords on that. That of course is a debatable issue, my lord. I will satisfy. I'll make an attempt to satisfy my lord. Now, so this is the case, my lord. This is the case. The only thing is the interest component, my lord. That is that. My lord, a wrong parameter has been applied to compute to calculate the interest. Wrong parameter, my lord. The law does not permit that.
Exactly.
The Interest Act 1978 very clearly says no. It cannot be done so. So therefore, my lord,
See,
that
again,
is
Mr.
that
Gautam,
is my
again, Mr.
contention,
Gautam,
my
okay,
lord.
see what we can perceive
Hmm.
is that right from the grassroots level, something wrong has happened,
My lord.
which is prejudicial to you. Fine,
My lord.
but in deference to procedures,
My lord.
you should have approached the next higher forum and the next, which you have not done so.
My lord, that
Perhaps
is where
only at a certain point you have come before the High Court and that's it. So how do we correct
my lord,
that situation?
my lord, that is where the second limb of my argument comes. My lord, admittedly, my lord, deceit, fraud, however we put it, has been played before the court of the first instance, and this decree has been arrived at, my lord. Now, my lord, the law is very clear that if finding of a court is a product of a fraud or deceit, etc., it is non-extant law, and it can be questioned at any stage, even in a collateral proceeding, my lord. Even in a collateral proceeding, it can be questioned, my lord. I will admit that, of course, we did not approach in fact, my lord, the entire approach, I will honestly concede to this, the entire approach of the state respondents has been very callous, right from the inception. They had the first opportunity to contest in the court of the first instance. Then there was an appeal filed. Against a finding in the appeal, there was a review filed. But all the matters, my lord, all the matters proceeded ex parte. All the matters proceeded ex parte because of the very careless manner in which the proceedings were conducted. And also, my lord, in the second appeal, the concession which was made in the second appeal was very wrong, my lord. At least an instruction ought to have been obtained, my lord. Without obtaining an instruction, my lord, they made a concession without realizing that if the question of double billing is left aside and whatever is left is paid off, a huge chunk, because the question of double billing was limited to a sum of only 21 or 23 lakhs. And such a concession was made and an order was passed in the second appeal without formulating any substantial question of law. My lord, so this is my case, my lord, insofar as my learned senior's question on the maintainability of my petition is concerned, my lord. My lord, since this is a matter where the other issue, the other matter is also tagged along. So, my lord, I have argued, I mean, in a nutshell, what my case is, my lord. So, my lord, I'll file my written submissions if my lord permits me. I'll file my written submissions, my lord.
Yes, you do that.
Because, my lord, admittedly here, even if we are to admit, if concede to their original case, they are not entitled to a penny more than 3.5 crores.
Fine.
I'll file my written submission. My lord will kindly allow me 2 weeks time. In 2 weeks time,
my written submission process is ready, madam. But I'd only like to draw your lordship's attention to this judgment, which was not brought on the court in the last date. Of course, I've mentioned it in my written submissions. It is the case of Virut Nagar Hindu Sabha and others.
What is the citation?
This is 2019, Volume 9, SCC 538.
Para?
Paragraph 11, 12 and 13. I'll just read 11, my lord.
Where is it? Is it here?
Hey, my lord, I will annex it with my. I'll just 11, my lord. Secondly, the High Court ought to have seen that when a remedy of appeal under Section 104, read with so and so of the Code of Civil Procedure, was directly available, respondents 1 and 2 ought to have taken recourse to the same. It is true that availability of a remedy of appeal may not always be a bar for exercise of supervisory jurisdiction of the High Court. Now, well, Lord, I'll annex this along with the. Now, what my friend was saying, that there's been fraud, trade, and deception. You know, that is a direct allegation even against the courts, because here's a judgment which has been upheld by the appellate court. On review also, the review application was rejected, and even before this court. Why the learned counsel considered, that is not for us to, at this stage, to look into. Well, the fact is that even after the decree is at page 70, of the reviewing petition. They have not annexed the plain document. In the plain, the suit has been valued at 8 crores 88 lakhs.
We have
Yeah. Decree, my lord, is at page 70.
No, plaint is there. Plaint starts from page
36.
Starts from page 33,
36. 36. My lord will see page 36 also. This
36?
The suit has been valued. Annexure 3, page 36.
Yes.
The suit has been valued at 8 crores 8 lakhs. And even the decree at page 70, the decree which my friend has shown, is also.
Yes, that is, you see, that is not disputed. You have filed this suit for recovery for this amount.
Yes.
and paid for interest at the rate of 12% per annum.
In fact, we should have got more if, as per the plaint, because we even paid for interest on the 8 crores. Now, my lord, out of the 8 crores, an amount of half the amount has already been paid, deposited by them, and withdrawn by us also. Now, can they at this stage now come and challenge all those orders?
It has been seized.
Yes.
Seized at the court.
No. That is half the amount. Half of the amount was already paid.
If the court decides that they are not entitled to it, we can file recovery proceedings.
How at this stage, madam?
Recovery of possession is always there. That is a different aspect.
Your Lordship, we'll see what is their prayer in this petition. Not only maintainability will come into play, but the principles of res judicata would also apply. So we'll come to page 20. Under 227, can this court now?
Yes.
Set aside and quash the entire proceedings in money suit number 24/7/2009.
Yes.
Since the date the matter was remanded back by this honorable court by order dated 24/2006, passed in RSA number 5 of 2016. So essentially what they're saying is that quash the entire proceedings after the order was passed by this court in RSA number 5 of 2016. Now RSA number 5 of 2016, my lord, is page. What's that order? Page 122. 120.
120, 120.
Just to recapitulate. Heard Mr. So-and-so, learned senior counsel, appearing on behalf of the appellant state, who submits that the respondent plaintiff admitted the fact that Bill 1157 to 1230 may be double bill due to mistake. The learned trial court below, by its judgment dated so-and-so, mentioned and reflected about the double billing, but has not considered the impact of the piece of evidence as referred above. Hence, the instant second appeal before this court. So essentially, my lord, when they had filed the RSA, it was only in respect of the double of certain bills only, of only bill number 115 to 1230.
And this will amount only to about 20 lakhs or so.
23 lakhs. 23 lakhs. Also heard Mr. So-and-so, learned so-and-so, assisted by so-and-so. Learned counsel for the respondent honestly submits that this is a fit case which needs to remand it back to the learned trial court for further examination in respect of those bills, so-and-so, so-and-so. So at that point of time, my lord, I had conceded. I said, in respect of these bills which appear to be double billing, let it go back and let the trial court examine, because it was not clear. So this court further held that I agree with the submission of so-and-so. State also consented to the same. Considering the facts and circumstances of the case and the submissions advanced by the learned counsel at the bar, the matter is hereby remanded back to the learned trial court concerned to look into the matter afresh in respects of the bills mentioned above. In the meantime, if the appellants desire, they can file an application before the learned trial court to explain the situation as to why, when they could not file the written statement in time, and the court to consider the same. It is also further mentioned that I am not going to set aside the entire judgment dated so-and-so, as the dispute between the parties regarding the double billing mentioned above only. Let the learned trial court confine to decide the matter regarding double billing unless it is required to examine other issues further. The learned trial court below is directed to dispose of the matter expeditiously and probably within a period of 3 months from the date of a certified copy of this order. The registry is directed to return back the lower court case record to the concerned court along with a copy of this order. In the meantime, if there is an execution proceeding pertaining to the disputed amount, that shall remain state until disposal of this case by the learned trial court below. And the matter was disposed. Now, by this order, in fact, the government was given a chance.
So you were referring to this order?
Yes.
Where the second appeal was
disposed of. This is the finding in the second appeal, my lord. This is an order which passed in the second appeal while no substantial question of law was framed.
The question now before this court.
It was dealt with like a summary procedure, my lord.
Even then, I think the issue that was confined here is only with regard to the double billing, not the entire degree as such.
No, my lord.
Because the court says it is not.
This is what the counsel appearing is, my lord. My lord, a second appeal, my lord, when there is a second appeal, my lord, the second appeal is basically on the points of law only. On the points of law only. So, in the second appeal, while drafting a second appeal, the facts are narrated and what is assailed is narrated, and then a question of law is formulated by the appellant.
Yes.
So, my lord,
by no stretch of imagination, issues of law are suggested, and the court will formulate the.
Exactly.
Yeah, here's a case where we have conceded. This is the case where respondents have conceded. We said yes, we are agreeable that in respect of the amount which is disputed, let us go back. So where was the question of, formulating a substantial question of law?
That is the entire content.
Anyway, my lord,
where is the finding?
Anyway, my lord, this court sitting under 227, can it re-examine this, the correctness of this order? That is the issue.
That would amount to review.
So what I am saying is that, my lord, all these orders which they seek to impugn by this way of this review petition is barred by the principles of res judicata also. Even after this court, my lord, this court has given them a liberty to approach the trial court in respect of this double billing. Go before the court, file your petition. They never did so. Then the trial court even in respect of double billing, it went ex parte. And what made this particular petitioner to file this revision petition at this stage, my lord, was the fact that the State Sports Council, which is the other case, my lord, will have to take into consideration that the person, this particular person at that point of time, was the director of sports. He was also holding the post of the Secretary, State Sports Council. Dual post, dual charge. Now, as Secretary of the State Sport Council, he files CRP number 21 before this court at the first instance and claims himself to be a stranger to the suit, and money has been deducted from the account of the State Sports Council by the trial court, which per se is illegal. That is the subject matter of the other revision petition. And in that revision petition, interestingly, he makes the director of sports, he himself, as the respondent number 3, and comes rushing to court. Of course, the court also at that point of time maybe had thought that how could the trial court do such a thing? How could the trial court attach the money which is lying with the State Sports Council when it is a different entity altogether?
It's not a judgment debtor.
And it's not a judgment debtor. So they came running to court, obtained a stay on the remaining sum, which is around 4 crores. Obtained a stay from this court. So that money is still lying in the bank till date. After that was filed, then they come up with this. The same person now, Director of Sports, come up with this CRP to counter whatever, to try to undo whatever the mistakes they have done on the earlier occasions. Coming back to the other case, Manoj. Now, there was a stay from this court on being prima facie.
As far as Mr. Gautam's case is concerned, you are done?
Yes, my lord. I'm done because, as I said, 227, the scope is very limited. If the court has to allow this petition, this court will have to set aside all the orders passed by the trial court, the appellate court, and the judgment passed by this court in the RSA, which I showed. So there is no scope whatsoever.
So as far as this case is concerned, you can file your written argument.
I'll file my written argument.
Ready also with that, yes.
Madam will kindly give me 2 weeks time. I'll
with
file
the authorities.
Yes, I'll file a complication.
Please.
I'll file a complication on these 3 issues. The interest component, maintainability.
Only a few facts, my lord.
Are you here in this case also?
Yes, my lord. Which may stand corrected, my lord.
Yes, sir.
No, these are corrected matters, my lord.
No,
I am arrayed as responsible for the application, my lord. That is CRP 21, my lord.
No, here you are.
In this case, they are not.
In 28, you're not there, no?
No.
28.
28, they are.
We are in 28 now.
28.
Yes. But it emanates from the same matter.
Yeah, of course, but
Only
we'll have to.
Only one correction, my lord. Because it was stated that throughout in the lower court the case remained uncontested, my lord. That is not true. The case was contested, my lord. Even till the end it was contested. Even against this order, my lord, this case was filed. Against this ex-party order, immediately this case was filed. That you could not have extracted. How can you demand money from a party which is not a party to the proceeding? Even those cases were also filed, my lord.
Why have they brought? They should have brought those onto record.
My lord, the question
If that is the fact, my lord, that they have filed before, then they are barred of from coming to this court by way of 227.
No, my lord, may kindly see. Now, lower court record has not been called, my lord. Has the record been called? A lot of facts will be.
If the contention of my learned friend is correct, then it will be very good for us, in the sense that if they have filed such miscellaneous applications before the trial court, then where is the scope of filing 227? In fact, that would be my submissions.
What is the order passed thereon?
Yes. Even my lord is well aware of section 47.
If I correct, because it's a long matter.
Then
That's what I've been.
Effective orders will pass, my lord.
That's what I've been trying to say all along, my lord.
You get your facts in orders.
Yes.
Mr.
My lord, only thing is that that is so much.
Lower court records have not been called for.
No, my lord.
No, they have been called for. I
Done
think right from the very beginning, the
Yeah,
records have
yeah.
been called.
Lower court records are here.
Yeah, my lord, because that is.
You want to peruse the court, lower court record, you go.
Before the next date, at least I will peruse. No, it's a long matter, my lord.
Agreed, it's a long
Matter, my lord. In fact, my submission in the other case would be under section 47. It is their duty to go before the trial
Now
court.
that ex-party also, my lord, it had gone behind the back, my lord. That order was passed behind the back of the state respondent.
So have they got and filed an application for
That
setting
is exactly
aside?
what I am saying, my lord.
They've come rushing to this court, my lord. If they had filed those petitions, then where is the question of filing this 227 here?
No, that is why I am submitting that all along the petitioner has plead fraud. He has weaved a web of deceit before.
No, but
My lord, I think they
if-
should take.
if you are-
that is a very serious
Yes.
insinuation.
Because if you are
by the
if you
petitioner.
are complicit in the matter, then
Yes.
what is to be done?
No, by saying that, he's casting aspersion in the courts. Also.
No, my lord, I'm clearly saying that.
I am standing here behind decrees passed by the court. If he is going to submit that fraud, I played fraud, that means the court also is involved. They should take away such submissions.
My lord, I'll file my
The court
written
would not
submissions.
be party to
But
all
the
those
court
things.
has been
The
misled.
only the court
The court has been misled.
could have been misled. That is the only thing.
The court has been misled, my lord.
Leslie.
Clearly.
Leslie.
One court could have been misled, my lord. Here there are 3-4 judgments upheld by this court also.
So if something has started on a wrong footing, it would have.
What is void ab
it would have
initio?
gone all the way.
My lord, what is void ab initio cannot be subsequently corrected, my lord. Anyway, my lord, I'll file my submission.
But Mr. Prasadi, you are not in this case, isn't it?
No.
Not
Then
in
why
what?
have
Not
you?
in this case, but I am, my lord, for the state, my friend is appearing in this case. In the other case, I am for the state, my lord.
My lord, in this case, I am a specially engaged counsel for the state.
So let us pass an order here.
My lord, will kindly give me 3 weeks time, my lord, to file my written argument, or 2 weeks.
You take your time. Yes.
Because the issue here is only maintainability, only on the ground of
Yes,
maintainability.
I'll let my
But the see.
my lord, as it is on day one only, I have considered
But
to
the
that.
narrative would would let one to assume to to come to the conclusion that it's a very murky.
Very murky issue, my lord. Very murky issue.
My lord, sorry to interfere, my lord, but in support of my friend, whatever he has stated, my lord, in the second appeal which was filed, my lord, of course, I do not have the copy with me at the moment. My lord, all these grounds were taken, my lord, what issues and whatever my friend has said, all those grounds were taken in the second appeal.
And
And
my
yet
friend,
no-
and my friend has assisted the
Yes.
senior counsel.
Yes.
Please don't forget that. He had assisted the senior
Yes,
counsel.
of course. I'll have to go by whatever my senior said. Of course, I was there.
My lord, this of course, my lord has rightly says that it's a very murky issue.
Anyway, the court will consider the matter and will pass and see orders.
Alright.
So,
My lord, will kindly give me about 2 weeks time to file my written submissions. My lord, I'll file a compilation.
heard Mr. K.C. Gautam, learned counsel for the petitioner. Also heard Mr. T.T. Dino, learned senior counsel appearing for the respondent.
Sold.
Only one respondent?
Yes. In this case, only one.
Mr. Gautam has submitted that he may be allowed, on conclusion of his argument, the learned counsel for the petitioner has submitted that he may be allowed to file a comprehensive written argument with related authorities, for which some time is sought for.
And we also, my lord.
Similarly, the respondent has also made a prayer for filing of the written argument. on prohibit the same law. This is matter after 2 weeks.
Obliged.
Now 21, what do we do? Yes.
I beg an apology, Your Lordship. Your Lordship, I'm handicapped to give any submission in absence of the senior conducting counsel, Lordship. I pray if this matter may come up after.
As paid for by the counsel of the petitioner, this is matter after 2 weeks. We come on the same date.
Yes.
Okay.
Item number 10.
Yes,
Lordship, they have, as per the last order, the management committee has filed the affidavit, Lordship. There was an order.
Yes.
This is actually on the last occasion I was asked to prepare the compiling any book or judgment which I accepted. This is.
So,
Lord, as per the last order, my Lord, there was a direction to file a rejoinder, my Lord. To the
No, actually it's not required.
On record, 1st February, 1st November, Your Lordship.
Rejoinder actually this.
yes, you are appearing for 5 and 6.
Yes, Your Lordship.
So you have filed your
Yes, sir.
counter affidavit. Now they are supposed to file their rejoinder.
No, actually I have gone through the affidavit. It's
Okay, so
not.
you-
It is
okay,
up to
so
me whether.
it's up to you, that's what I said.
I'm not filing, Your Lordship,
You're not
because
filing, so
the annexure, everything, whatever is annexing, it's the same annexure which they have annexes filed by the state respondent, Your Lordship. That's why I said that it's not required,
yes,
Lordship.
fine.
And my Lord, as far as this is concerned, he was directed to file an advance copy, my Lord. So,
No, on that day, actually, I wanted to reach, but Lordship just keep it for time being. That's why. This is just nothing is there. Only just prepare and only the page is there.
What is this, Mr.?
This is only the some books which
find
we some book list means like only some act. Very relevant to this subject
No,
matter.
this-
Just
this-
enclose and file it so that
No, what
it,
is this? This compilation is how is it related to your?
no, this is only the say for example the education code one
Whatever,
education.
whatever. You will be relying on
Lordship.
on the contents of this.
Yes, Lordship.
So
If they wanted to go through, let them go
what is
through.
what is the rule?
Otherwise, otherwise this is nothing. Just I put it so that I just book where the X is, what the X is.
No,
Just
but you have
prepare list
you-
accordingly.
You have also annexed some authorities here.
yes, my Lord. So that is why he was.
So
There was actually a direction that he should give us an advance.
So in effect, Mr. Sangma, this would be your written argument.
This is literal argument like that only.
This matter has been heard.
Not this, Lordship.
This will, if required, see, at the time of filing of a comprehensive written argument, you can do so, bring all this and
Yes, yes.
annexing all this.
Now,
So as not to complicate the issue.
yes, yes. Now this is only just a list of book, Lordship.
Whatever.
Lordship.
Please start.
Okay, Lordship. Your Lordship. This petitioner hearing, she was appointed as a teacher, assistant teacher in the school of Hirapara SSA UP School, District West, Garo Hills on 28 September 2015, Lordship. That is on Annexure 1, Lordship. Appointed on 28
just a moment.
to Lordship.
Page
15, man. It's a type copy.
appointed as teacher.
28 September 2015. Lordship, thereafter he has been continuing in service for some time, since 2015, around 4-5 years, Lordship. Thereafter, Lordship, she was alleged that she have contested in the Rabah Autonomic District Council, Lordship. And then the managing committee.
My lord excuses me just for a minute, madam.
Yes.
Just
Oh,
need to.
yes, please.
The managing committee, I can continue, I think.
Yes, please continue.
The managing committee of the school have released the petitioner from the school, saying that that you are released from the school, that they don't want me from the school anymore, since they want me to discontinue, saying that I have contested in the election, that Rabah Hazong Autonomous District Council on 21st February 2019, and accordingly on that ground they have released, means they have released the petitioner on 15 February 2019, Lordship. 15 February, that is in Annexure 2, Lordship. Annexure 2, page 17, where it says, Lordship, with reference to subject stated above, we, the SFC member of Hirapara School, had decided to releasing you from assistant teacher from your school with effect from 15 February 2019 due to contesting 19 Dan Rabah Hazong Autonomous Council on 21st January 2019. According to the higher authority, we have concerned that without resignation or without concern with the authority, have no right to contest any type of election. So, based on the rule and regulation, here we releasing you from from our school. This is the releasing, means that they have, Lordship. Then thereafter, Lordship, lecture 3, it's a page 3. They have provided this letter. They're saying that this is the letter issued by the director, additional director, school education and literacy, district mission coordinator, SSA, West Garo Hills. In the letter dated 27 March 2019, it says that please enclose here with the petition dated 14 February 2019, received from the President Hirapara UP School complaining against the conduct of Srimati Florita, that is petitioner, assistant teacher, and CRC coordinator Hirapara, which is self-explanatory. You are therefore requested to inquire into the matter, and submit a detailed report to the office of the undersigned within a week. This is the way actually they are supposed to conduct an inquiry on me, against the petitioner, Lordship. Now, your Lordship, I will take you to the Annexure 5, Lordship. Annexure 5, page 22, Lordship, when it says that this is the letter from the order from the administrative and account officer, SSA West Garo Hills, Tura, dated 15/5/11/2019. Where it says,
no inquiry was conducted.
No inquiry was conducted. I'll come to that. There was no inquiry conducted, and prior to releasing the petitioner from the school, there is no approval from the district, from the authority, Your Lordship. That I will come to that, Your Lordship. Here, that there is an order, Your Lordship, on variation of the report of the SSA, so and so, dated 8/08/2019, submitted Block Commission Committee, Trikila BRC. It is observed that no prior permission or approval was sought for contesting election MDC in the Assam by Srimati Florita, which is against the Rural Department. Thus, in view of the above and desired by committee for taking necessary action from this end, the undergoing for preventing such practice in future by any employee, do here release Srimati Florita the moment from the post of cluster coordinator of Hirapara CRC, while allowing her to continue the service as assistant teacher of Hirapara UP School with strict warning to be more responsible henceforth. The headmaster of Hirapara is hereby directed to take over the charge of office of the cluster coordinator Hirapara CRC with immediate effect. Now here, why this is the very important, one of the cases, that since there was a complaint against me, illegally or rightly, without any procedure, that also, but however, I was released from the, I'm holding the post of two posts. One is cluster coordinator, another is the assistant teacher. Now in this order, they have released me as a punishment. They are releasing that from the cluster. They have released me from the post of cluster coordinator, and they have allowed me to continue as a service as in the post of assistant teacher, Your Lordship. However, Your Lordship, the state respondent and also particularly the managing committee, even after this order, they have not allowed me to continue in service. Violation of this order. The order is clearly speak. There is article 19 or 20 is very clear that it's become a double jeopardization. Here already I have punished. They have released me from my service. Even that too illegally, without serving any notice, without prior information, without giving an opportunity or calling it an explanation or whatever it may be. So, however, they have released me and accepted, and they still allow me to continue in service. And that was not allowed. They physically didn't allow me till from the date of the releasing order till now. They have not allowed me to continue in service, Your Lordship. Thereafter, my Lord, may I come to the this page 8, not page 8, Annex 8, page 28. This is very important, which I would like to place my case, Your Lordship. This is here. What happened? This is the letter order, District Mission Coordinator SSA West Garbage Tura, where it says that. May I just read, Your Lordship, the letter. It was departmentally released from her service from the post of CRC based on your complaint and unauthorizedly contesting MDC election without any knowledge and permission from authority. She was departmentally appointed for CRC. Regarding the termination released from assistant teacher duty of the SMC, since SSA norms and SMC are empowered for teacher appointment, the said teacher was appointed by the SMC Hirapara School. The DMC approved the appointment done by the SMC to all the SS school. Therefore, you are hereby directed to issue the press order immediately to the assistant teacher whose service is unwarranted to your school as your claim letter 25 November 2019 without sending any complaint to DMC office. The DMC already done its part. The copy of the action taken report should be submitted to the court undersigned without fail. Your Lordship, what happened? They have complained against me, and they're saying that to issue against me any if they don't want the petitioner anymore in the school, there is a direction to issue the press termination or any order against me. But now till now there is no forthcoming neither any termination order is forthcoming from the managing committee. That is my case. Now I will come to their affidavit. Now my submission here is that there was allegation against me that I have contested the election, but as per the rule, I will come to that later. Now, before coming to that, Your Lordship, I will just come to the affidavit filed by the state responding, Your Lordship. Annexure 1, page 10, Lordship. The affidavit in opposition filed by the state respondent.
Yes, sir.
Page 10. Here, this is the letter issued by the Additional Director of School Education and Literacy.
Yes, sir.
Wait.
Yes, sir.
Page 10. Page 10 of the affidavit in opposition filed by the state respondent is filed by the director.
This is dated 6/7/22.
Lordship. Here they don't mention the date. It will be the yes, Lordship. I just read the only time I will take you to the annexure.
Yes, sir.
Yes, madam, it was filed on 6/7/20.
Annexure 1, Lordship. Annexure 1. Annexure 1, Your Lordship. Page 10. May I read, Your Lordship?
Page 10, yes.
Lordship. With reference to such I am to inform you that report submitted by white number so and so dated 25 April 2009 with regards to the inquiry into the complaint against CRC coordinator Hirapara by you, it is observed that you have not conducted the inquiry involving both parties, but has submitted only the reply submitted by the coordinator, making it difficult for the undersigned. And in understanding the matter, it is in its entirety. You are therefore requested to once again inquire into the matter involving all the stakeholders and submit a detailed report to the office of the undersigned within a week's time, so as to enable the undersigned to initiate the necessary action from this end. This is the very clear way they have admitted, and there was no inquiry at all. Now, Lordship, I will just take you to the page Annex 2, that is next to that, page 11 and 12, Lordship. The page 12, I will not read the entire, but I will just read the portion of it. Page 12. Page 12, second para. The same affidavit. Page 12, Lordship. On inquiry about the procedure of releasing her from the post of an assistant teacher, the undersigned have observed that SMC did not serve so-called notice or explanation call before issuing the release order to Srimati Florita the moment. The undersigned also required the final decision of the SMC member and observed that there was mixed response. However, most of the SMC members decided not to take responsibility in their own hand. Instead, decided to hand over to the district mission coordinator to make best decision in order to function the school smoothly. This is for your kind information and necessary action. Now, my lord, what happened is from the record, it is clearly, so it is not my version, it is their version, it is on the record. It is very clearly that first instance, while releasing the petitioner, number one, while the managing committee, while releasing the petitioner from service, they have never given any so-called notice or explanation code to the petitioner till date. And secondly, there was no any approval or information to the government authority prior to releasing from our service. And on record, it is their admission that no so-cause was issued to the petitioner, and also there was no inquiry lodged. Now, samely in the private respondent, they have annexed that, saying that there was a notice, some letter was issued, but nowhere. Now they have to establish me that how I have received those papers. There was no indication, there's no proof, and to show that I have received those petitions, that they have to establish. Now I will just come to this lordship, and to that effect also, your lordship, they are also aware, even at the time of hearing, there on numerous occasions, court also has passed an order to produce some. Lordship, this is part of the record only. This is the order from this court only. On the 3 occasions.
My lord, that fact is already over. On the last occasion, my friend made the same submission, my lord.
Okay, that's
lord,
not barred me from
repeating, my lord. This fact is already over.
For protection of the record.
Yes, my lord. The court has seen also. The subsequently order also passed. Yes, over and again he is stretching on that.
No. What I'm saying is, but they are not able to bring the inquiry report.
What records are required? Because
my lord,
substantially, what is there?
That lordship. I'm not stressing, but it's a part of that.
Yeah, as far as your case is concerned,
lordship,
you say that there was no inquiry conducted.
Lordship. No explanation code.
The state also has admitted that show cause notice and all the procedure has not been followed. So
that's it. Now I will just come to this lordship. I have given the copy also. This is just page 1 of my which I have compiled. This is nothing. This is just yes, lordship. Page 1, lordship. I have given to the page 1. This is actually from the beginning. This is the book on the Meghalaya Education Code. Meghalaya Education Code. That act, original name of that act. Educational Code, section 9, lordship. Chapter 4, page 1, lordship. I'm just taking to the page 1.
Yes, it's there.
Page 1, section 9, section 2, your lordship. This is very clearly stated that subject to any rule page 1, my lord. I think.
No, page 1 is there.
Yes, lordship. Page 1 there, chapter, it is written chapter 4, terms and condition of service, employee of
Oh, okay.
lordship. Now, lordship, good. There is a terms and condition. Now, the section 9, subsection 2, lordship. I am relying this.
Yes.
It says that subject to any rule that may be made in this behalf, no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated, except with a prior approval of the competent authority. So it is clear, my case is that it is their admission. They have released me from the service without following this provision. There was no approval, prior approval from the district state authority. And now page 15, your lordship. This is the same thing, but then this is the actually that I don't need to repeat, but since this is the taken from the Education Act, my lord. The education, it's starting from page 5. This is the Meghalaya School Education Act 1951, page 5. Then I'm relying on the page 15. Page 15, there is a section 4. It is the same thing has been repeated here, where it says where managing committee of a recognized private school intend to suspend any of its employees, such intentions shall be communicated to the competent authority, and no such suspension shall be made except with the prior approval of the competent authority. That lordship. Now I will take you to page 54, lordship, of this one. Page 54. Now why I am taking this one? This page 54, the government Meghalaya have amended the rule of conduct and discipline of employee of aided educational institution as follows. This one actually para rule 6 and 7, your lordship. May I just read it, lordship. Rule 6. That's the amended of rule 6 is written in excess of rule 6 of the word except in accordance with provision of rule 7 may be omitted, and another provision to rule 6 shall be omitted. Now what is the main access, your lordship? Page now what is the rule 6 and 7? It is page 63, your lordship. Page 63. Page 63. This is the rule regarding conduct and discipline of the employee aided educational institution. Then the earlier the main act which they have the rule 6 and 7 prior to amendment.
Yes.
The rule 6, it says that no employee shall offer himself as a candidate for election to a legislative body or for looking office of any political organization except accordance with provision of rule 7, provided that the employee may seek an election as an independent candidate of a panchayat with a previous approval of the managing committee, as the case may be, but he shall not be entitled to accept any office there except in accordance with the provision of rule 7. Now rule 7, your lordship, is that any employee desiring to seek the election to legislative body or to hold the office of any political organization or local body shall be on compulsory leave without pay from the date of filing his nomination till the announcement of the result by the proper authority, and shall be eligible to rejoin his post immediately. In case he is elected, he shall be on compulsory leave without any pay from the date of filing of his nomination till the termination of his office to which he is elected. Such elected employee shall be allowed to retain in lien on his post for a period not exceeding the full term of elected body to which the employee is so elected. In the event of such employee joining the force against which he has lien, the interim period of absence on compulsory leave will count for national increment benefit of pay from the date of such reasoning. Your Lordship, this petitioner earlier, this
But this
rule was already
this has been omitted.
amended, and later the High Court, Lordship, this division bench of this High Court has already set aside that notification of March decision, which means that the teachers are allowed to continue in the exam. That notification is in the judgment, Your Lordship, page yeah, it starts from 78, Lordship, page 78, and I will just read the relevant. It's starting from page 78. That State of Meghalaya versus Bright Stalwart Malbanyang and others. I will come to the relevant portion only. The page 95, para 31, on para 31, then till 1, 2, and para 33, Lordship. It is needless to enter into debates as to whether right to vote and whether consequently or otherwise right to contest election at any legislative or public body is an inherent right or a constitutional right or mere legal right as long as it is recognized as right. However, may only be said that once the preamble to the Constitution declared the state to be both democratic and republic, there is a promise held out therein that, subject to what may be prescribed by any procedure established by law, any citizen of this country would be entitled to vote and contest election to legislative and public bodies. Paragraph 32. Though it may be banner in going through the etymology of the word democracy and its Greek origin, democracy in modern day is popularly understood the word of Abraham Lincoln from his Gettysburg Address of 1963, where he referred to government of the people, by the people, for the people. Both the principle of the people and by the people encompass the wider concept of the right to participate in the formation of government by both having a right to vote and right to contest in the larger sense of what that concept of democracy convey. Doubtless such right may be curtailed, but that must be under due authority of law. Again, in this great nation was also conceived in liberty and dedicated to the proposition that all men and women are created equal right.
This is not relevant.
Yes,
You know only what is relevant.
relevant is that because that one is already the notification, the amendment that is already says. Now I will just like to rely also the judgment by the single bench. I think this is the Lordship, this is your order, your Lordship. I will just take you to the page. Page 73.
Instead of referring to paragraph 34 of this judgment, you have omitted this.
Yes, what suits?
You have read what is not necessary.
Yes.
Let's see.
Paragraph 34 of this judgment you have not read.
What suits me?
Where the notification was set aside.
Yes, Lordship. I went to, it is there actually.
And in fact, my lord, this notification is not even enclosed here.
Notification is there, Lordship. I have enclosed.
Where is the notification?
I've shown.
That page 54?
Yes, 54 is there. Page 54. It is there, Lordship. I have enclosed. I think my line friend might have oversee that one. Page 54. It is there, my lord. Now, my lord, the similar situation case where my lord have allowed in the case of Siljon A. Sangma versus State of Meghalaya, page 71, your lordship, page 71. This is relevant to my case, your lordship. This is same situation case, the procedure. I'll just take you to the page 74, 71, page 71, 71. I'll not read the entire lordship, but
Just go to the relevant para.
only the relevant para. Para, I will read just para 8, 9 and 10 lordship. Another limb of the argument advanced by the petitioner is that the impugned order, page 73 lordship, I'm looking. Impugned order was passed in complete violation of the petitioner's right in as much as no explanation was called from the petitioner, nor prior so cause notice was issued to him, and no inquiry was also conducted against him to enable him to answer to the charges made as indicated in the impugned order. Even otherwise, the school of the petitioner being a recognized private school, the provision of Meghalaya School Education Act 1981 is applicable, and subsection 2 of section 9 of the said act provide that, subject to any rule that may be in this behalf, no employee of recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated except with the prior approval of the competent authority. In this provision, it has been violated as much as the prior approval of the competent authority, who it is in joint district mission coordinator director, has not been obtained by school authority before termination of the service of the petitioner. Herein submit now, lordship, this para 10, lordship. Finally, the Land Council neither has submitted that this court may be pleased to set aside and quash the impugned termination.
This not relevant.
Lordship, relevant, but lordship, this order, this petition was allow you, lordship, this last para 17, page 76. 17. Overall consideration of the matter impugned termination order dated 24/08/2017 issued upon petitioner by the chairperson so West Garden Hills is set aside and quash. Petitioner is hereby directed to be reinstated. Now it is the same similar matter while I'm trying to place this cause. The same yardstick was issued here in my case also. None of this procedure was followed. There is no so-called explanation. No prior approval was taken from the authority, from the concerned authority, prior to my termination. Now, from the APDB, the election after I filed this repetition in on February 2021, they have filed the APDB in the month of July 2022. Only on that in that APDB, they say that I have been terminated, but terminated and the so cause was issued, but no way to show that those termination or alleged notice issued to me was never served to me. I have never received. That is my statement. That only they are saying that whether required to follow file the rejoinder. That my record state may be recorded. My only submission is nothing. Those termination letter, the explanation code, nothing was served to me prior to releasing or releasing from the service lordship. And from the record, it is they themselves have admitted from the APDB in opposition. From the record in the annexure where state respondent and also the managing committee, they have been closed in the same day. There was no inquiry conducted. That means the violation of this statutory provision of subsection 2, section 2 of section 9 of Education Code clearly violated, lordship. That is my only submission. And there was a judgment, lordship, where it says I may not be in a smoothly articulate before this court, but still, lordship, from the annexure, from the court order, is very clear that this petitioner is without following any due procedure, they have been removed, even if considering the everything is that. That's my only submission, lordship.
Yes.
Although main answering respondent would be the managing committee member, but I have a few things to revert to the submissions made by the petitioner. My lord, yes, initially there was an inquiry and then they said that the inquiry was not proper. Will you please redo the inquiry? Thereafter, my lord, the inquiry was redone, and then thereafter, my lord, in our affidavit we have stated that the petitioner was also there in the proceedings, in the inquiry proceedings.
In your affidavit, you have said that.
Yes, sir. most importantly, my lord, even before I go into that, my lord, the petitioner has approached this honorable court. But my lord, the very fact is that, my lord, when he had approached this honorable court, she had approached this honorable court, her services were not terminated, my lord. However, my lord, during the pendency of the proceedings before this honorable court, my lord, her services were terminated. My lord, her services being terminated, then this writ petition itself becomes infructuous, my lord. Because first and foremost, she will have to challenge her termination order. What will be the outcome of the writ petition, my lord, even if it is to
Yes, because you see, if I can understand correctly, the only point you have stressed is that you have not been terminated as an assistant teacher, but
As a cluster.
But as
Cluster coordinator.
Cluster coordinator. Yeah, you have been removed from that.
Lordship, exactly.
So because of that, you have come before this court.
No, I'm mainly is because they have released me from the school that order against the order of the managing committee. Well, they have released me from my service. And secondly, Lordship.
So release means terminated.
Yes, it is amount to terminate. They don't allow me to continue in service.
There was no order of termination, my lord. Formal termination of order followed, my lord, only. Yes,
And that termination, as I have submitted, Lordship, they have never communicated to me.
Approving.
And now they have to establish before this court that this termination letter was issued to me, and they have to tell me that, establish me that I have received those. I am denying those, Lordship. That is the thing.
So, Mr. Prasad,
my lord,
if you say that he has been terminated in due course,
yes,
and now he is saying that he has not received, copies or notice of such termination or copy of the order.
Whether termination, my lord, whether is it necessary to supply a copy to the petitioner, my lord?
Naturally.
Necessary.
My lord, as far as the.
You mean to say that if somebody is terminated?
Resolution passed. My lord, there was a resolution passed by the managing committee. That was dated, my lord. That was dated 11/8/2020, my lord.
Where is
that is at Annexure 4 is the termination letter, my lord.
Annexure 4 of what?
Annexure 4 of our affidavit, my lord. The government affidavit, page 15.
So this is the complaint.
This is the termination letter, not page 50.
Sorry. Yes, termination letter. So this was issued by
managing committee.
Managing committee.
Managing committee.
I do hereby inform that the school managing committee, Hirapara SSCP school, have been terminated due. This is addressed to her.
Mr. Sangwa.
Now, my lord will kindly see this is already addressed to her.
Yeah, no, you said that you have not received this.
No, I said this particular termination letter I only received only while they have filed the affidavit. Yes. Not prior to that. Exactly. That's why I'm saying.
Okay. Have you filed?
He should have challenged.
Have you filed a rejoinder to this?
No, I didn't file it rejoinder, but.
My lord, this will have to be challenged, my lord.
Yes.
This letter will have to be.
No, Lordship, what happens with challenging it will exist. My only submission is that whatever maybe the termination letter or anything or even the resolution, everything they have to supply the copy. That is, and also they in their affidavit they are clearly stated that there was no inquiry. There was no inquiry is conducted against me. It is their admission. It is on record. Have it been that this was given to me and supplied to me, then I should.
My lord may kindly.
But now if we just go, then it will be the.
My lord may kindly allow me to read my earlier letter, my lord, which is at Annexure 2, page 11, which my friend has conveniently left out because it does not suit. Page 11, my lord, Annexure 2. My lord, may I take my lord to the third paragraph? My lord?
Yes. So we
This
go.
is my inquiry, my lord.
Yes.
That madam, during our inquiry, the assistant teacher come, CRC coordinator Shrimata Florita D. Moment gave her statement that she contested at 19 so and so Autonomous Council as an independent candidate, which was held on 12 January 2019. The 21st January 2019, she also told that she informed the head teacher through her father, as she was unable to come and meet the head teacher as well as the SMC. It was also stated by the head teacher of the school above mentioned school that her father took signature from the head teacher on a blank sheet of paper, and the head teacher of Hirapara UP school Sri Sangseng Sengan Momin given his signature with seal on the blank sheet of paper without the knowledge of the other SMC. We inquired about the same Srimati Florita D. Momin, CRC school of Hirapara SSA school, unable to produce it, stating that it was misplaced somewhere at home. This is the statement of the petitioner.
No, it is just
She was there in the
now.
inquiry.
That's why court have asked that if there was any statement, there is a separate sheet of the statement.
And my lord, this is
How can
dated
we
8/8/2019. This is dated 8/8/2019.
And they have stated again, they themselves it is there on admission, saying that there was no inquiry.
My lord, this is regarding the earlier, my lord. This is 15th Feb 2019. This is
That's why
SMC
court has
school
called
held
for the
meeting
record.
on 14th Feb 2019, and it's missing. The SMC members had decided to release Srimati Florita D. Momin, assistant teacher come. Yes, assistant teacher come,
Since-
CRC coordinator of Hirapara SV school, from her duty with effect from 15th February 2019 for a misconduct. Now this is referring to the earlier one. This inquiry is 8/8/2019.
That's why
This
I have
is referring to a
this is-
resolution which is 14th February 2019. So in the subsequent, my lord, she was allowed to participate, my lord. This itself is clear. The madam, during our inquiry, the assistant teacher come CRC coordinator gave her statement.
That's why court
This
has
refers
asked
to-
the
refers to
record
an earlier
of
date.
her
Just-
statement.
Just a moment, sir.
Lordship,
You,
Lordship,
you'll get your turn to reply.
Lordship.
Lord, this refers to an earlier date, my lord. What it says, it was also informed that SMC of the above mentioned school held a meeting on 14th Feb 2019, and its meeting, SMC members had decided to, there was a decision to release Florita D. Momin, assistant teacher come CRC coordinator of Hirapara school, from her duty with effect from 15th February 2019 for her misconduct in duty. On inquiry about the procedure of releasing her, this is referring to the month of February, my lord.
Oh, okay.
Not the subsequent. On inquiry about the procedure of releasing her from the post of an assistant teacher, the undersigned had observed that the SMC did not serve show cause notice or explanation call before issuing the release order. So this is referring to the earlier. In this inquiry, she was very much there. Now this paragraph only refers to the meeting which is held on 14th February
See,
2019.
Mr. Bhattacharjee,
Yes,
you have referred to this inquiry report,
Yes.
which, according to you, indicated that she has, participated in.
Participated, my lord.
So, was any show cause notice issued to her? Any, charges framed against her?
My lord, this was an open inquiry. She was called in the inquiry, my lord. Because this is a spot inquiry, my lord. So spot inquiry, my lord, normally what happens? Everyone is called for the inquiry. That inquiry will be held on such and such date. So please all of you be present on that.
But is that a correct procedure?
My lord, this is the procedure, my lord, followed in most of these schools, my lord, because I have dealt in several matters, my lord. Most of the inquiries are conducted in this manner, my lord. There is always a spot inquiry. That is exactly why a notice will be issued earlier, that on such and such date there will be inquiry, please, against so and so. So you please be present on that date. So that.
Another thing, so you said the records are with the court, all these records?
So my lord, this letter in original was produced before the court had released it.
No, what this court would like to see is, before coming to this stage of the inquiry report, so in your record you would have, copies of the notice issued, where she has also received copy, all those things, and then proceedings, how the proceedings were conducted. In the, you see, perhaps you, before coming to this final report, there would have been something noted that
they had supplied us the original letter.
they have, you see, there would have been records of proceedings where so and so was examined, and this is what they stated, as has been noted that she has also stated that she has left those papers at home. All those things must be there. It must be in the proceedings.
Should be there, my lord. But because what was produced to me before. Another aspect, my lord, because if I'm not mistaken, there also was a bifurcation in the district, my lord.
Oh, this is.
I'll follow it up. I'll try to get that. But this original, my lord.
No, you keep it with you, but you produce the entire record. Particularly, with reference to this inquiry report dated 8/2018.
Now,
19th.
now, my lord, let us assume, my lord, that let us assume for instance, my lord, that this inquiry there is no record. Now, what will subsequently happen, my lord? This termination letter is of a later date, my lord. It is dated 25/1/2020.
See, but the termination letter would have been, would have been the culmination
sorry,
of.
my lord, I stand corrected. I stand corrected, my lord. My apologies, my lord. This letter of termination is, my lord, even prior to the filing of this writ petition, my lord. My lord will kindly see. This is at annexure 4, which we have enclosed, my lord. I stand corrected, my lord, because earlier I had submitted that during the pendency she was terminated. That is not correct, my lord. That is in fact incorrect, my lord. So petitioner ought to have challenged this first.
We will challenge, that's why I am
One
saying.
second.
They have not.
This is 25/1/20.
2020.
Yeah.
This repetition is of 21.
That's why I have said.
So, my lord, first and foremost, the petitioner ought to have challenged this.
No, but now she is saying that she has not received copy of this.
But this is addressed to her, my lord.
Exactly. So now, exactly. So why records are required is in your records you would surely have.
My lord, if I'm not mistaken, my lord, the managing committee will definitely.
Whatever, you see, whether it could be from managing committee or from you. This was issued by.
This is issued by the managing committee.
Headmaster.
Yes.
Headmaster.
And the approval was granted eventually, my lord, in the year 2020 itself. November. This is the approval. So this approval, my lord, the petitioner is not required to give a copy.
No, that of course.
So this, why I said that at that moment I had stated that it is not required. Petitioner is not required to be supplied any copy is relating to this manner, the approval letter. Termination letter, obviously the managing committee will have to supply to the petitioner. So this is much prior to the filing of this instant writ petition.
No, but you see, the procedure demands that the termination order, as was usually done in case of appointment, is done by the managing committee. And because it is a government-aided school, the approval would be given by the concerned authority.
Yes.
So in this case also, the termination order was passed by the managing committee. Subsequently, the government would approve that.
Yes.
So that has to be on board. And then finally, the incumbent or the petitioner in this case would be intimated of the final approval by the.
Final approval
To say that the managing committee has recommended for your termination, you have been terminated, and we have also approved the same.
My lord, as far as my understanding, my lord, is that normally what I have seen, my lord, even in cases of appointment, my lord, it is the managing committee who appoints.
Yes, exactly.
After appointment, my lord, they issue a letter to the petitioner saying that we have been appointed, and then they send it for subject to approval. It is always written in all appointments, my lord. Then what happens, my lord? They send it to the state. So once the state grants approval, my lord, so the petitioner's appointment is
is finally granted, my lord, because approval is
Okay, in that, see on the same line, you would also say this, that the petitioner was terminated by the managing committee, subject to approval. Yeah. So then the approval eventually came.
Yes, my lord.
That approval has to be conveyed to her.
My lord, to my understanding, my lord, because I have not
Then,
seen, I'll have to
I
see
mean,
some cases.
just think of it logically.
No, because, my lord, the letter is addressed by the managing committee, my lord, to the authority. So the authority will respond to the managing committee.
Yes. Yes.
But, my lord, I
The
don't
managing
remember
committee,
if I-
yes, the authority would respond to the managing committee because you had sought approval
Yes.
from the authorities concerned. But that, see, the
my lord, I have
contents of
not come
the
across
contents
an
of that
instance.
approval has to be.
I have not come across an instance.
But how can-
whether-
then how
where
would you-
managing. So I'll try to find that out also. my lord.
that-
Even from the appointment letters, I'll try to clarify that. my lord.
Because it doesn't sound logical.
My lord, because what follows is matter the correspondence is between the managing committee and the
Yes.
state authorities.
So now it is incumbent upon the managing committee to then, convey the approval of the authorities concerned to the petitioner or to the incumbent. To say that on approval being given by the school authority or whatever, you have been hereby terminated. So to that extent, you will find that the chain is complete.
So, my lord, that is, my lord, maybe my lord is correct. So, my lord, if that be so, my lord, even then the petitioner, most important would be to challenge these. These are not under challenge. in the incident
Again, you're
petition.
saying the same thing again and again, challenge, and in the same breath, they are also saying that, or she is also saying that she has not received copy of this. She has not received either copy of this letter, this particular letter, only when you file this affidavit, and also the relevant approval order.
My lord,
That is not there.
let the managing committee submit, my lord. Then thereafter, in the meantime, I will also try to get the correct picture. My lord.
That's why on the earlier occasion I'm saying that.
Because what the petitioner
on
should have
query,
done, my lord.
last time also court has asked to
one
produce.
second, let me submit. My lord, on submission of this affidavit in opposition, my lord, we will submit only on the basis of the record that the office maintains.
Exactly.
Whatever record has been supplied to us by the managing committee. Because all records are not with us.
See, as far as your role is concerned, it is well defined.
My lord.
It is not your controversy.
My lord.
It is a controversy between the managing committee and the incumbent. What you do is your role as the authority concerned who is required to approve any action taken by the managing committee. You have done that, but how you did it, that's a different thing, of course.
No, the only thing is that, my lord, immediately after, even assuming that petitioner is saying that, my lord, that this copy was never received. So, my lord, immediately on submission of our affidavit in opposition, my lord, having gone through the records, petitioner should have said that, my lord, I may be allowed to withdraw this writ petition with the liberty to file afresh to challenge these.
That is, yes.
Because in the present form, my lord, whether this writ petition is maintainable or not.
That is, of course. I have pointedly asked Mr. Sama whether you have filed a rejoinder to this. He said no. So,
Exactly.
it means you have accepted it as it is.
Exactly. So, my lord, let the managing committee submit in the meantime, my lord.
I think we'll do one thing. We'll call for let the relevant records be produced. Your record as well as your record.
I filed affidavit and brought notice also, which was supplied.
Hey, that's what you may have. What you do is produce the record, of the original. Where
Your Lordship, that what your Lordship is suggesting for the directing for the records of the inquiry. It is though inquiry held in the school premises, but record was with the office of the subdivision school education officer. So it has no access with the office school.
As far as the inquiry is concerned,
It is.
so yes, inquiry was conducted by SS.
No, this is a subsequent inquiry. Of course,
there was subsequent inquiry.
But whether on whether show cause notice is
Yes.
not served.
Whether show cause notice have been issued and received by the petitioner, because the petitioner is denied.
Because I have annexed your Lordship notices.
That's what I said already.
Okay.
But I'm denying. I have never received all those documents.
Why not verbal deny? Will it do?
No. That's why they have to show. Establish before the court that if there is any receipt, then I will be there will be a signature of the petitioner or through postmaster.
My
They have to show.
My lord, whether I have received.
They can make any create any document also.
My lord, whether I have received. One second. Let me submit. Whether the petitioner has received or not received, my lord, that has to be refuted in an affidavit.
Exactly.
A rejoinder affidavit. You never filed that.
Yes, sir.
My lord, verbally saying that I have not received, my lord, will it suffice?
No.
Who is making that submission?
So he is making submission.
Then I will fight on the affidavit on record. Just
It was
just
very
to
much-
state it that
your lordship was directed on 1st November that
no even
as soon as
she
he
was
received
allowed,
the
even
affidavit-
she has even
Allowed,
the
in
right
fact,
to file the affidavit was provided only.
Mr.
7th, I have
Mrs.
provided
She has just filed it only yesterday only.
not yesterday 7th I have provided.
Even then,
Mr. Sangma,
even then,
Mr.
lordship.
Sangma, at the outset, see, when the letter counsel for the respondent 5 and 6
Taking signature, we
has
have
brought this affidavit on record, brought the notice of this court to the affidavit file, I had pointedly asked you whether you would file a rejoinder to the same.
Yes,
You
you
said
declined.
you said I have gone through it
and he says
and we are not filing.
Yes.
Now at this stage you're saying filing because there are some incriminating evidence against you.
Yes.
Lordship.
Which you cannot, as Mr. Bhattacharya has rightly said, you cannot just refute it, verbally.
Yes.
Because what you are saying now, you can deny tomorrow.
Yes.
No, Lordship, even same thing what happened, even she have opted not to file the affidavit. The
That's
court
what,
has
that,
allowed.
you see, on prayer, on prayer made,
That-
this court has allowed. But you have not done. You have said,
No, that's why I'm praying, Lordship.
on the contrary, you have said we are not filing.
Only
Lordship,
what do you say?
Lordship, since I withdraw that particular this one,
Not only
but
to assist this
since
on
it
the
was
record.
no order has been passed, so I'm making this prayer now,
Order
but
is
there is
passed.
no bar on my part,
Order
so
is passed.
I can be allowed
But the
at
order,
the same time.
order is very clear. You see, so as not to delay the matter, you have been asked to file the rejoinder within, in fact, today itself.
yes your lordship it should
Because
be
I just received the notice only recently only.
Your lordship,
Whatever.
Lordship, now I doubt.
Even if you have,
Lordship,
even if you have received it, maybe 1 or 2 days ago,
7th
You could have.
Lordship, that's why I'm making a
Seventh,
prayer
your
that
lordship, 7 days he has
I'm
got.
asking this court now. If required to be filed, I'll file small application and
My lord,
pray
he
to this court.
took a decision that he will not file, my lord.
I
Now, just to assist this honorable court, my lord, earlier what had happened, my lord, the respondent counsel was unable to contact the respondents at
no,
all.
that is the making an excuse.
No, my lord, it is part of the order.
my
Yes,
disease
part-
No, that is he
part of the
just
order.
just an
see,
excuse.
now we are only on, we are only, on some technical issues, some procedural aspect of the matter.
Yes.
But overall, when you look at the case of the petitioner and see the basic reason being that she was ousted from service because of her participation in the election.
Without behind the back, my lord, without permission.
without permission your lordship without
This is a
seeking
misconduct.
permission of the managing committee
This
he
is
participated.
she participated in a proceeding without letting the managing committee that she is participating.
Okay. Have you pointed out in your affidavit
yes
Yes,
I-
yes.
yes
Okay,
yes
both of
yes,
and the relevant rules?
rules
Yes.
No, nothing.
Apart from those, because 6 and 7 has been decided by the judgment of this court, so that is you see.
No, my lord, the other two judgments, the judgment that my friend has produced, because he has produced it only today. So I will examine these also.
Yeah, because I think that
Because here, my lord, only it is saying that a certain amendment is quashed.
yes.
It does not say otherwise, my lord. The order of this honorable court, the division bench, says the notification dated 23rd, I think
23rd March 2021.
is set aside.
to
As
that
it says,
effect
right?
is set aside, my lord.
So now what happened is since that notification has been set aside, so the original rule 6 and 7 will remain.
Remain.
And the incumbent, as was done in the case of the petitioner there or the appellant therein, that he was allowed to contest for election. So that remains. That situation remains. Now in
My
this
lord,
case,
my lord, there, if I correctly remember, my lord, although I'll have to know about the history of the
Yeah.
case, but if I remember, my lord, he had given an application.
no, that is exactly. See,
So the difference, my lord, here you are doing behind the back.
exactly. So if that is another aspect of the matter
Yes,
which has
my
to be
lord.
considered.
And that too signature is sought by her father in a blank paper.
That we are denying, Lordship.
Wow. Inquiry of
Because that's why
everything is-
they are saying they have
then,
not
my lord,
conducted
Mr. Sangma,
inquiry.
Mr. Sangma,
my lord,
let us. You are the person concerned. Before contesting for the said election, have you sought permission? Have you, if not permission, so let's not say permission. Have you informed the
Yes,
authorities?
we have informed.
No.
They're saying
Have you annexed that in your petition?
they themselves.
No. Have you done that?
No,
It's
he's
your
not,
case.
no.
It is your case that
Yeah.
I was released from service because I had participated in the election. Okay. The fact remains that before contesting for the election, I have sought for permission or I have informed the school authorities or the authorities concerned, and this is the letter I have done so. Is that there in your petition?
No.
No, it is not there, Your Lordship. Not only that, he was issued no show cause notice.
So now
that's why.
So now this court will examine the legal aspect of that fact, whether without informing the authorities concerned, you can participate in the election. As far as participation is concerned, perhaps that is also
That's a
subject
different
to.
aspect.
That is a different. Maybe you are
Because when
allowed.
you are filing an
Maybe you may be allowed in view of the judgment cited. But whether that is the precondition is that you have to seek permission
But
first.
another aspect is that my
Or-
plea is that maybe any illegality or anything. My only submission is that the procedure has to be followed.
That is a different aspect.
That's why there was a time and again
That
in
is
the
a different
earlier
aspect.
order also.
You
not
see,
saying.
as far as your ground on the issue of show cause, on the
Yes.
issue of the inquiry being conducted without giving notice to you and all those things, that is a different aspect.
That-
for which the court has called for the relevant records.
Regulatory records.
And my lord, another aspect. My lord, my friend has stated that Meghalaya School Education Act will be applicable, my lord. My respectful submission that this act will not be applicable. I have recently got a clarification from the government also, my lord. The only rules that will apply is the SSA, that is the right to school education RTE Act, my lord, and the RTE rules 2011.
No,
those are the rules and acts which will be applicable.
Then
and not the because this is an
then they
SSA
have to
school.
challenge that order passed by this honorable court where the SSA teacher was allowed. In the case of Siljong and this one, he's a SSA teacher.
Oh, that's a different aspect.
Different aspects.
It's not for you to say.
And my lord, in that case, my lord, that case he is not challenging. He was not terminated because he participated in some election. This is a different matter altogether.
Different matter,
And
but
the only, as you pointed out, the only point that was raised there and decided by this court is on the issue of natural justice being violated.
Yes.
So that aspect
Yes.
can be taken in any proceedings. And if you say in this case that the principle of natural justice was denied to you, that will be examined. But again, in the backdrop of the relevant rules and procedure and the communication between you and the respondents.
then let them produce the record. At the meantime, Lordship, my only prayer is that I may be allowed to just file small affidavit to the rejoinder affidavit to the this.
Fine.
May I please, Your Lordship, before parting with this case today, I want to point out that in the writ petition paragraph 1, petitioner has stated that she is a resident of Nunthumai, whereas affidavit sworn in is Mogopada. Your Lordship may kindly have a look at the affidavit in opposition, affidavit in the writ petition, Your Lordship.
That is
Also I have brought in affidavit.
fine. We'll consider
there is another defect.
present and permanent residents.
No, but it should
That I will clarify, Lordship.
But Your Lordship, only one thing.
This is just
that
address.
Just a moment.
Your Lordship, he doesn't.
Allow.
Your Lordship, just a minute, Your Lordship,
Yes.
for sake of adjudication by the Your Lordship. That affidavit shown in at page 14, Your Lordship. My learned friend has stated that resident of Mogopada, P.O. Boida, West Hills district, Meghalaya. Whereas the managing committee has informed me that this address belongs to Gwalpada, Assam, Your Lordship. Everything is wrong in the petition, Your Lordship. How Your Lordship will adjudicate this matter? Even date also in the prayer portion that he has been appointed from 2013, whereas his appointment letter at Annexure 1 is 2015. In everywhere mistake is there in the petition. Better petitioner, maybe Your Lordship may be pleased to direct the petitioner to withdraw and file fresh,
No, no.
annexing all the
Why should
termination order and everything.
if there is a
Your
some
Lordship.
small
No,
aspect
Your
of the
Lordship,
matter, we can just correct
each and
it.
every line
Who is he
mistake
to
is there.
ask me to withdraw? It's my liberty.
No, I am seeking permission.
If it is
to-
found that you see there's a difference. There is a difference between committing mistake.
Lordship.
See, committing mistake is okay, but there is also a difference between omitting. You see the fact.
Yes. But
Omitting
here
facts
there
and-
may be a bona fide mistake. I'm not omitting.
Everything is
Maybe
a
some
mistake,
address,
Your Lordship.
some date. That usually it happen, Your Lordship. That can be corrected.
How come, Your Lordship, without
In
amendment?
the
And
first-
these things it happen.
My lord, in the second paragraph of the writ petition, it stated that the petitioner was
Appointment
appointed
date is also mistake. Your
White
Lordship.
appointment order dated 22/9/2015.
Where is it?
However, my lord, annexure 1, if my lord goes to annexure 1,
28 Your Lordship.
That Lordship, I may be just allowed to correct it
appointment
because
is dated
the
20th
annexure,
September
but I have not hide any fact. The annexure is there. It can be considered because there is a typographical mistake.
Yes.
Instead of arguing on law, there will be these things. Typographical mistake error used to happen, Lordship.
No, Mr. Sangma. These are very material.
Even in other courts also, Your Lordship, when we find any mistake, we are directed to amend it or withdraw it and file
That's
it.
why I'm saying
This
that
court
I
on
may be
many-
allowed to correct it.
This court on many occasions have allowed the parties to
Yes, Your
take
Lordship.
necessary steps.
So,
my lord, in the prayer portion also, which is at page 12, my lord. My lord, where the petitioner is claiming for release of salary. my lord.
No, that is already done. Prior to filing of this one, they have not released. Now, after filing of this petition, they have released.
1 second, my lord.
When I tried to speak, they said
Just
they
no,
didn't
no, just
allow.
no. He has not done. He is not done.
My lord,
They get angry. When I speak,
if I
they
may
get
read, my
angry.
lord,
But that issue of releasing is already done.
Lord, if
I
I
already
may-
got the money.
draw my lord's attention to the end part, my lord. Page 12. My lord, direction should not be issued to set aside and quash. My lord has found it.
Page 12.
Page 12. Or else I'll read the whole prayer.
No, direction should not be given to the state
Should not
respondent.
be issued to set aside and
Where is
quash
that?
Uh,
the impugned order dated 20/12/2019 by the district mission coordinator SSA West Garo Hills,
No,
Pura,
I-
and allow
ju-
her to continue in her service, my lord.
Yes.
Or as to why direction should not be given to the state respondent and the private respondents to release the salary of the petitioner with effect from 15 to 2013.
13.
Now, my lord,
Yeah,
appointment-
2019.
No,
No,
Your
Lord.
Lordship.
19.
with effect from 15 to 2013 to
No.
December 2019.
Yeah. No, here it says 2019 with effect from 15 to 2019 to December 2019.
My lord, here it says 15 to 2013.
No, this issue is over. We got the money after filing of this petition. Money has been released. It is in the order also, Your Lordship.
No, that
Now
is-
this issue is over.
Mr. Sangma,
Lordship.
just a moment. If there is any wrong statement given, then you'll be liable for that.
My lord.
Our petition
Here-
is like that only.
If the petition given to the court and the petition copy given to the parties are different, then
No, she said. See.
Court is not talking
This
about
issue
the
is already
My lord,
there,
if-
Lordship.
if I further
We
read-
already got the money after this one.
just a moment.
By this
If
court.
I further read, my lord. Or as to why the sum of rupees 3,000 which were deducted from the monthly salary of the petitioner since from the date of her appointment should not be returned to the petitioner with effect from 22/9/2015.
Why is
Here also, my lord, there is a defect in the date.
Yes, appointed
Till
in
date.
20.
Till date and or as to why rupees 3,000 deducted from salary of the petitioner since the date of appointment till he was released from her service should not be released to the petitioner or may pass such other order or further orders or direction as your lordship may deem fit and proper. Again, my lord, here I come. Meanwhile, pending disposal of instant writ petition, your lordship further be pleased to issue direction to the respondents to pay the salary from 15th February 2013.
What is the appointment?
Here it's 1919.
19?
To December 2019.
Mr. Sama, I think you have to have a look at this.
That money already paid, Your Lordship.
No, that is beside the
No,
point.
but you will kindly see the prayer.
Just have a look at that portion. You said 2013.
Yes, my lord. In our copy, it is 2013.
So
It's
yeah,
19. No, it is 19. Actually, we have corrected earlier, Lordship. This is there will be an order to this. Whatever the mistake was there, it's already corrected. This only because they have not checked the report.
Okay. Can you? But you
My
see,
lord, may kindly.
if it is corrected by this court order, then in the there it should.
Exactly, my lord. The question of correction will not come because in the court copy it is different, my lord.
Yeah.
If there is a correction, there will be a signature, my lord.
You check your Lordship.
This is only with regard to the salary.
Lordship, salary only. That
Anyway,
and
that can be-
moreover, the salary already we got it.
Anyway, that can be ignored.
That is ignored because it is addressed already. This
That is
date
addressed.
But
That will not.
Then whatever the date,
will
that there is only mistake on the date of
That
appointment.
is only. That
Mistake
will,
on date of appointment.
Address also, Your Lordship.
Date of appointment and the address. If they're saying that that I may be allowed, just I will correct it.
Everything to be corrected.
No, that one.
So you do it. Then. See, we have. I thought today the hearing would be completed, but
Only they should raise this one earlier prior to.
Raised, Your Lordship, with this
If there is
issue,
any reason, then there should be an order.
it's incumbent
Now-
upon you. It's incumbent upon you. You see, yeah, you are responsible for giving the correct facts.
And that too affidavit, wrong affidavit, address wrong.
My lord,
An
even
an affidavit is to be taken very seriously.
It is written oath, Your Lordship. Affidavit is written oath. West Hills, there is no name is.
even
West
your
Hills.
lordship
You
on
do
the
it then within. First, you do the correction.
Then, instead of correcting him,
Then we'll proceed with the matter.
My lord.
fresh with challenging the termination order.
Necessarily, this you see, 1 hour or more than 1 hour is
My
just
lord,
wasted your
only my
lordship
respectful
precious
submission
time
is
here.
that, my lord, even if it is corrected,
Still,
my lord, what will come out of it, my lord? Because here, what my learned friend is challenging for setting aside and quashing the impugned order dated 2012-2019,
what is
which is
termination
not a
order?
termination order.
because
Termination order
they
came
are going back
subsequently.
again same your lordship, because first time they have not
Well,
even
now
complied with this
Doesn't
order.
matter, Mr. Sama, it is your case. It is your case. Whatever you choose to do, do it. If you have made a prayer to citing some impugned order,
That impugned order, because the after releasing the order, that I am satisfied. They have released me from the cluster. Again, they asked me to terminate. That's why I have to impugn that order. That impugn is there. That is the correct impugn only. The order, lordship. I'm challenging
Okay,
because
whatever-
without going to the file, they are just making noise.
that we will look into in the. when the
I'm
matter is-
challenging the order 20
Yes,
December 2019.
Yes, Mr. Sama. That will be looked into when the matter is heard again.
Lordship.
But in the meantime, if you wish to firstly correct your
Date of
petition,
appointment.
yes,
Everything, Your Lordship.
correct the whatever is there,
Affidavit also,
whatever
Your
is
Lordship.
wrong in the body of the petition, you do that. Secondly, if you wish to file a rejoinder to the affidavit by the respondent, do that. But only one opportunity will be given to you.
Lordship.
May I please, Your Lordship, just a suggestion, Your Lordship, with the due permission of the Honorable Court, Your Lordship. Instead of correcting, since my learned friend is in possession of the termination order, better he can withdraw and file.
No.
That is up to
My
you.
lord, if he doesn't want to challenge it, is
So
up to
it's
him.
better instead of correcting.
It's okay.
I'll correct it and by the
How will you
rejoinder
correct it?
affidavit.
you make a you see, once your submission is made, the court will take that into consideration.
My lord, he'll file a rejoinder to the private respondent.
Lordship, I'll file it.
And correction of the petition also.
Yes.
Correction of the petition also.
After this matter has been heard at length,
How to be corrected? Amended petition.
the learned counsel for the respondents have pointed some apparently clerical or typographical error in the petition. Mr. P.T. Sama, learned counsel for the petitioner, has also conceded to such error being committed and has made a prayer that the same may be allowed to be corrected. Accordingly, the petitioner is petitioner is directed to take steps in this regard. As to the rejoinder to the counter affidavit filed by the respondent 5 and 6 respectively, though the same has not been filed today as has been directed by this court, in interest of justice, the petitioner as prayed for is directed to is allowed to file the said rejoinder. However, only one opportunity will be given to the petitioner to do so, the same to be filed in the next date fix. How long?
After 3 weeks, Lordship, because so many things have to be done.
Yes, I think.
Lordship.
Because next week I will be out of state.
He is only.
No problem, I will just.
He has
find-
only what is 3 weeks? Fine. This is matter of the 3 weeks.
Lordship.
Sorry, your lordship, is precious time is wasted
Anyway,
for our income.
Auspicious, Lordship.